Senate will come to order. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook, Creighton, Eckhart, Flores, Gutierrez, Hagenbu, Hall, Hancock, Hinojosa Nueces, Hinojosa Hidalgo, Huffman, Hughes, Johnson, King, Colcourse, Menendez, Middleton, Miles, Nichols, Parker, Paxton, Perry, Schwartner, Sparks, West, Zaffarini.
Quorum is present. Please rise for the invocation to be delivered by Pastor Ethan Maytott, Red Rocks Church in Austin, Texas.
All right. Very honored to be here with you all. Thanks for having me. I don't think my wife believes that I'm actually here today. Thank you for taking a picture to prove it. Let's pray. Heavenly Father, we come before you during this most consequential and important Holy Week, thankful for your grace, for your mercy, for your sacrifice and your love for us. God, you are all-powerful, you are present, you are mighty, you are loving, and you are forgiving. And today I lift up to you my brothers and sisters right here in this room, holding power and influence, and I ask that you administer to and through each of them. I pray for each of them to personally know your love. I pray for blessing and favor on their lives. God, you see each of them in the challenges and valleys that they walk through, and you have victory and hope to bring to their lives. And so today, I pray in light of who you are, that this room of your children would be compelled to fight for the things that our city, our state, and our nation are desperate for, things that come from you. Hope, unity, freedom, purpose, and love. God, our lives are in your hands, so would you lead and guide us in your purposes and power and not our own. Today we pray all of this in the powerful name of Jesus. Amen. Thank you.
Thank you, Pastor Maytott. If everyone would please welcome to Pastor Maytott to the Senate. The Dean of the Senate moves to dispense with the reading of yesterday's journal. Is there objection? Chair hears none. Motion is adopted. Mr. Doorkeeper,
Mr. President, there's a message from the House.
admit the messenger.
Mr. President, I am directed by the House to inform the Senate that the House has taken the following action. The House has passed the following measures: HB 500 bonding.
Thank you. The following message from the governor. The secretary will read the message.
To the Senate of the 89th Legislature regular session, I ask the advice, consent, and confirmation of the Senate with respect to the following appointment. To be a member of the Upper Neches River Municipal Water Authority Board of Directors, Johnny A. Allen Harrington, Palestine. Respectfully submitted, Greg Abbott, Governor of Texas, to nominations.
Chair lays out the following resolution. The Secretary read the resolution.
Senate Resolution 409 by Eckhart et al., recognizing April 15, 2025 as Blue Ribbon Lobby Day at the state capitol.
Chair recognizes Senator Eckhart on the resolution.
Thank you so much, Mr. President. Members, please join me in welcoming Texas Democratic women to the chamber this morning. Woohoo! I often say, ladies, government is us, and for government to work, we've got to show up. These women are here representing the over 100 years of getting our country closer to the ideal of equality, which is more than fairness for all, but real progress that leaves no one behind. Since 1987, when Governor Richards was then State Treasurer Richards, and our nation was in the grips of an AIDS crisis, these Democratic women have been making the case for policies that advance our public education, health, and economic prosperity, all of which support their families, their communities, and the continued right for women to be in chambers like this. With over 20 chapters across Texas with thousands of members, there's no doubt that these ladies fight hard. And this is what keeps this democracy we share alive. Not just every 2 years, but every day. Members, I believe it is urgent that we heed the call of these women in ensuring there remains equal access and opportunity to our democracy, because their futures, the futures of their families, depend on it. I'm increasingly grateful for the presence among our ranks today. And I will see you in the halls today, tomorrow, and the next day until we have full equity in the United States for women and men. Thank you so much, members.
Chair recognizes Senator West.
I would be remiss if I didn't say welcome to your state capitol, ladies. And I join Senator Eckhart in terms of this particular resolution and look forward to seeing you throughout the day. Thank you very much, Senator Eckhart, for this resolution. Thank you very much, Mr. President.
Chair recognizes Senator Zaffarini.
Thank you, Mr. President. Mr. President, members, what a pleasure it is to join Senator Eckhart in welcoming the Texas Democratic women to the Texas Capitol. We are so honored to have you with us today, and I hope that you will notice that there are 8 women in the Texas Senate, 4 Republicans and 4 Democrats. And the women who work so hard alongside men also appreciate the men who work with us, because as we reach out to little girls and tell them that they can grow up to be anyone they want to be, we also have to make sure that we give good examples to boys so that boys and girls in Texas can grow up knowing that they can do whatever they want, and whatever you and the women in the Senate and I have accomplished, they can do even more. Thank you for setting such a wonderful example, not only for women, but for men and women of Texas. We honor you, we respect you, we appreciate you. Thank you for joining us at the Texas Senate. Thank you.
Chair recognizes Senator Hinojosa of Hidalgo.
Thank you, Mr. President. Thank you, Senator Eckhart, for bringing forth this resolution today, 409. I must say, Senator Severini, that women do all the work, men get all the credit. But in reality, those of us who run for public office, those of us who look for volunteers, those of us who really get to ask for help are people that really work and get down into the weeds. These are the women on Blue Ribbon Day. Thank you for what you do in helping our community, keeping us strong, helping all of us who are in public office do our jobs and keep us honest. God bless you all.
Chair recognizes Senator Menendez.
Thank you, Mr. President. I rise to thank Senator Eckhart for Senate Resolution 409, recognizing these wonderful, amazing people who do this because they care about our community, our state. It's good to see so many of you, my friends up there, and everything you do for public education, for our children, for health care, for all the things that really matter. And you know, thank you for not giving up on the process and making sure we get involved. And so we need to get that next generation enthused and excited, and we look forward to seeing you as soon as we finish here to go out and get some more volunteers to join your ranks and follow your leadership and your mentorship. Thank you for all of your hard work. We couldn't be here without you. Thank you very much. Thank you, Mr. President.
Chair recognizes Senator Eckhart to close on the resolution.
In closing on the resolution, I just want to say there was a time not long ago when representative democracy meant that women and people of color needed to find a sympathetic white guy to represent them. But that day is no longer, and it's because of your hard work. So let's keep going so we never go back. Thank you so much.
Is there objection to the adoption of the resolution? Chair hears none. Resolution is adopted. Chair recognizes Senator Hinojosa of Nueces for recognition.
Thank you, Mr. President and members. I'd like to begin by recognizing the dedicated leadership behind Operation Christmas RGV. Vice President Victor Anzaldúa, Secretary Araya Miranda, and Treasurer Aisha Guijarro. These individuals have shown a deep commitment to serving their community with compassion and purpose. You guys in the gallery, please stand if you are. Don't see you in here. Operation Christmas RGV is a nonprofit making a meaningful impact across the Rio Grande Valley. Through year-round outreach, they provide essential resources, encouragement, and moments of joy to children and families in need. Their mission is a powerful example of what can be achieved when service is driven by heart and dedication. Thank you for your work in our communities, and I know they're here somewhere in the Capitol. I just want to welcome them. Are they there? Oh, there you are. Thank you, guys. Thank you for being here, and welcome to your state capitol, and thank you for all the work that you do.
Chair recognizes Senator Zaffarini for recognition.
Thank you, Mr. President. Mr. President and members, it is my pleasure to recognize the delegation of leaders celebrating Wilson County Day at our state capitol. Established in 1860, Wilson County was named in honor of James C. Wilson, a legislator and Methodist minister. Long known for its agricultural roots, the county is home to Floresville, proudly dubbed the peanut capital of Texas. And I assure you, that's where the world's best peanut brittle is made too. Rooted in resilience and rural pride, Wilson County continues to grow while preserving its agricultural heritage, small-town charm, and the unique character of communities including Lavernia, Poth, and Stockdale. The delegation is in the North Gallery, and I'd like to ask the individuals to please rise as I call their name, and then I'll ask the delegation to stand together. The delegation includes County Judge Hank Whitman, County Court at Law Judge Tina Hartman, County Attorney Teresa Nettles, County Clerk Genevieve Martinez, County Commissioners Russell King and Scott Aiken, and Gloria Cantu, Floresville Mayor. Will the entire delegation please stand and be welcomed to the Texas Senate? Thank you, Mr. President and members.
Chair lays out the following resolutions. Secretary, read the resolutions.
Senate Resolutions 322 by Zaffarini, SR 407 by Zaffarini, HCR 123 by Hall, and HCR 124 by Sparks.
This is a voice vote. All in favor say aye. All opposed say no. The ayes have it. Resolution is adopted. Members, if there is no objection, would like to postpone the reading and referral of bills and resolutions until the end of the calendar. Hearing no objection, it is so ordered. The chair recognizes Senator Campbell for an announcement.
Thank you, Mr. President. Members, the Committee on Senate Nominations Action Report from our Monday, April 14th meeting has been placed on your desks. In accordance with Senate rules, this report will be eligible for consideration tomorrow. Thank you, members, and thank you, Mr. President.
Members, that concludes the morning call. Senator Creighton, you're recognized for a motion to suspend the regular order of business on committee substitute for Senate Bill 2365.
Thank you, Mr. President. Members, Senate Bill 2365 relates to the use of personal cell phones by students during instructional time. Texas educators have increasingly voiced concerns about cell phones disrupting the classroom, and the data backs them up. Over 70% of U.S. high school teachers say that cell phone distraction is one of the major problems that causes disruption to the learning environment in their classrooms. Senate Bill 2365 addresses this by prohibiting students from using personal cell phone devices during class time so that learning can remain the focus. Senate Bill 2365 affirms a common sense principle. During class, students should be focused on their lessons, not on their phones. By getting these personal devices out of Texas classrooms when instruction is underway, the bill ensures teachers can teach without competing with Twitter or TikTok feeds or any other social media, and students can engage without distraction. Importantly, Senate Bill 2365 is carefully crafted with common sense exceptions. We recognize there are situations where a device is genuinely needed. Under this bill, any student who requires a phone for health reasons or as a part of a special education plan, such as IEP or a 504 plan, is allowed to use it as necessary. If a device is needed for critical health or safety reasons, a medical alert or emergency notification, the phone would be permitted as well. Senate Bill 2365 targets disruptive personal use during class, not legitimate needs, and we've made sure that no student is put at risk by this policy. This legislation respects local control, and this legislation also sets a clear expectation. We will not have cell phones being used in Texas public classrooms during instructional time. Members, this bill will make Texas a leader in protecting instructional time in the classroom. We've seen momentum growing nationally on this issue, where 24 states across the nation have enacted laws or policies to restrict cell phone and device use during classroom time. And with that, Mr. President, I move suspension of the regular order of business to take up and consider committee substitute for Senate Bill 2365.
Senator Creighton moves suspension of the regular order of business on committee substitute for Senate Bill 2365. Is there objection? Hearing none, rules are suspended. Chair lays out on second reading committee substitute for Senate Bill 2365. Secretary, read the caption.
Committee substitute Senate Bill 2365 relating to a policy prohibiting the use of personal wireless communication devices by public school students during instructional time.
Senator Creighton, you're recognized for a motion.
Thank you, Mr. President. Move passage to engrossment.
Senator Creighton moves passage to engrossment. Is there objection? Hearing none, bill is passed to engrossment. Senator Creighton, you're recognized for a motion to suspend the constitutional three-day rule.
Thank you, Mr. President. Move to suspend the constitutional three-day rule.
Senator Creighton moves suspension of the three-day rule. The Secretary will call a roll.
Alvarado, Bencourt, Birdwell, Blanco, Campbell, Cook.
31 ayes, 0 nays. Rules are suspended. Chair lays out on third reading and final passage of committee substitute for Senate Bill 2365. Secretary, read the caption.
Committee substitute Senate Bill 2365 relating to a policy prohibiting the use of personal wireless communication devices by public school students during instructional time.
Senator Creighton, you're recognized for a motion.
Thank you, Mr. President. Move final passage of committee substitute for Senate Bill 2365.
Senator Creighton moves final passage of committee substitute for Senate Bill 2365. Secretary will call the roll.
Alvarado, Bencourt, Birdwell, Blanco, Campbell, Cook.
31 ayes, 0 nays. The bill is finally passed. Congratulations.
Thank you, Mr. President, members.
Chair lays out the following resolution. The Secretary will read the resolution.
Senate Resolution 402 by Gutierrez et al. Whereas two staff members of Big Bend National Park, Deb Manley and Kathy Hoyt, have captivated the botanical world with their discovery of a new plant species, the woolly devil. And whereas Ms. Manley, a volunteer in the park's botany program, and Ms. Hoyt, a supervisory interpretive park ranger, first encountered the plant while on a hike in the park's backcountry in March of 2024. Nestled among the desert rocks, the plant featured fuzzy foliage and narrow maroon-colored petals that were unlike any species they had seen before. The discovery elicited tremendous interest among botanists and park staff were eventually joined by representatives from California Academy of Sciences, Sul Ross State University, and Centro Interdisciplinario de Investigación para el Desarrollo Integral Regional in studying and classifying the species. And whereas researchers dubbed the plant the woolly devil in reference to its hairy leaves and horn-like florets, and it was designated with the official name Ovicula biraduata in a new genus within the daisy family. Diminutive in size, the woolly devil ranges from 1/2 inch to 3 inches across, and it has been identified in just 3 small sections in Big Bend's portion of the Chihuahuan Desert. As an annual plant that blooms after desert rains, it has likely struggled to survive in the midst of prolonged droughts in its habitat, making its discovery all the more remarkable to the scientific community. Whereas uncovering not only a new species, but an entirely new plant genus is a rare and exciting scientific breakthrough, and Deb Manley and Kathy Hoyt may indeed take pride in the role they played in bringing this tiny marvel to light and furthering the study of the fascinating biodiversity found within Big Bend National Park. Now therefore be it resolved that the Senate of the 89th Texas Legislature hereby commemorate the discovery of a new plant species at Big Bend National Park and commend Deb Manley and Kathy Hoyt for their vital contribution to this undertaking.
Chair recognizes Senator Gutierrez on the resolution.
Thank you, Mr. President. Thank you for the opportunity, members. We have before us here on the floor 2 National Park staffers, National Park Rangers that are so important to our community, in Kathy Hoyt and Deb Manley. I want to thank you for being here today, but more importantly, thanking you for this incredible discovery. A few of us have been very fortunate to represent West Texas. Senator Flores, Senator Blanco, and myself are very fortunate to have represented and currently still represent this wonderful part of Texas that I try to tell every member on this floor about. It's the place where it's my soulful place. It's my peaceful place. It's the place where my phone doesn't work. And that's lovely. It's the place where I can go up to the Lost Mines or go down to the Window Trail and see the beauty of West Texas. And you just made it a little bit more beautiful for us in finding this amazing new flower, this new plant. Members, I want to explain to you how important this is, and I've talked to Senator Creighton about going out to West Texas and taking his daughters that aren't so little anymore, about what a wonderful place this is. Your efforts today have given botanists and scientists, and I know you also have Dr. Michael Powell up here with us. Dr. Powell, if you're up there, please stand. They've given doctors and scientists a new beginning, if you will. Something new to look at, something new to study that we yet don't know the effects of how that could benefit all of us. And so, members, I stand here today to ask you to welcome our National Park Rangers, our members here from the national parks, but also to tell you a little bit about Big Bend. And I urge you to visit this very enchanted place, the place where you see the Milky Way at night. And you really do. And it's the most beautiful thing you've ever seen in the world. And so with that, Mr. President and members, I move adoption, and I thank you. I thank you both for being here with us today.
Is there objection to the adoption of the resolution? The chair hears none. The resolution is adopted.
Hello. Okay. Got it. Thank you. City
Senator Perry, you're recognized for a motion to suspend the regular order of business on committee substitute for Senate Bill 1869.
Thank you, Mr. President. Members, Senate Bill 1869, modifying the schedules of controlled substances. DISHES currently has the authority to designate, reschedule, or delete a substance from Schedule of Controlled Substances. In recent years, people have challenged the Commissioner's authority to modify the schedules, and they have insisted that DISHES' actions are subject to rulemaking and judicial review. Senate Bill 1869 reaffirms the current law that Commissioner's modification of schedules is not subject to rulemaking and that Commissioner's decisions are final, binding unless altered by the legislature. With that, I move to suspend the regular order of business of committee substitutes, Senate Bill 1869.
Senator Menendez, for what purpose?
Questions of the author, Mr. President.
Senator Perry, do you yield?
I yield.
Thank you, Mr. President. Thank you, Senator Perry. So, a question, if the federal government were to deschedule a drug at the federal level, would that somehow keep the state from complying, or does that mean that DISH's commissioner has to still make that change here?
So my basic understanding is we can be different on controlled substance schedules from the feds and the state. So that distinction is if the feds are and we're not, or we are and they're not. I think there is a flexibility for states to be different than federal. If federal does something, it would still require the commissioner to make the decision on what's on or what's off. What was that conversation is, the last couple of years we've tied up in litigation that there was some controlled substance conversations as being added, deleted, or modified. The entity suing the state said they didn't have that, and I've got 4 different cases in the courthouse that says DISHES and the commissioner both can do it, and he is the final authority on what is and is not on that without formal rulemaking or judicial review.
So does your bill set out any kind of process for a public input, or is it just...
It's granted to the agency by the legislature today and requires no judicial or public or rulemaking. And that's the current law today. They were stuck in court over this issue. We're just reaffirming that the current law allows it, and I can give you a couple of references to the Constitution. Section 8, Article 5 of the Texas Constitution grants all actions, proceedings, remedies to an administrative body instead of granting this authority to a district court. And then in 16, there was a case of Morath versus Sterling City. Supreme Court held that terms of the final and binding in the Texas statute prohibits judicial review of an agency action. Authority for DISHES to interpret its own statute is Crum versus Houston Municipal Employee System. Supreme Court affirmed that the legislature is permitted to grant governing entities the authority to interpret their own statutes. So the control stuff is additions, modifiers, and deletions has never been one that required rulemaking or public. That's just something they're granted to. Typically, you measure to where the feds are. Typically, we're going to be in sync with the feds. We aren't always,
right,
but typically we are. So that's just something internally they can do and not wait every 2 years or go through a judicial process to put something that's harmful or take something that's not off.
Yeah. So just as an example, I think if I hear you correctly, just to get this, and this is my last question, if the federal government were to declassify THC or cannabis as a controlled substance, the state through this process could still keep it a controlled substance classified. Is that what you're...
It absolutely could. And to be clear, though, there are penalty provisions that attach to those controlled substances, correct? The penalty provisions would have to be statutorily changed. So they don't have the authority to change the penalty structure attached to a controlled substance. At the same time, they can change the mix of the controlled substance.
Thank you for answering my question.
No problem. Good bill.
Senator Perry moves suspension of the regular order of business on committee substitute for Senate Bill 1869. There is objection. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook.
23 ayes, 8 nays. The rules are suspended. Chair lays out on second reading committee substitute for Senate Bill 1869. Secretary, read the caption.
Committee substitute Senate Bill 1869 relating to procedures for modifying the schedules of controlled substances.
Senator Perry, you recognized for a motion.
Move passage engrossment.
Senator Perry moves passage to engrossment. There is objection. The Secretary will call the roll.
Alvarado, Bencourt, Birdwell, Blanco, Campbell, Cook, Creighton, Eckhart, Flores.
23 ayes, 8 nays. The bill is passed to engrossment and will hold there.
Okay. 2. Okay.
Senator Perry, you're recognized for a motion to suspend the constitutional 3-day rule.
Move to suspend the constitutional 3-day rule.
Senator Perry moves suspension of the 3-day rule. Secretary will call the roll.
Alvarado, Bencourt, Birdwell, Blanco, Campbell, Cook.
25 ayes, 6 nays. Rules are suspended. Chair lays out on third reading and final passage of Committee Substitute for Senate Bill 1869. Secretary, read the caption.
Committee Substitute Senate Bill 1869, relating to procedures for modifying the schedules of controlled substances.
Senator Perry, recognized for a motion.
So moved.
Senator Perry moves final passage of Committee Substitute for Senate Bill 1869. Secretary will call the roll.
Alvarado, Bencourt, Birdwell, Blanco, Campbell, Cook.
23 ayes, 8 nays. Bill is finally passed.
Mr. President, members.
Senator Huffman, you're recognized for a motion to suspend the regular order of business on Senate Bill 1124.
Thank you, Mr. President. Members, at this time, I move to suspend the regular order of business, take up and consider Senate Bill 1124. Members, when the legislature passed the Michael Morton Act in 2013 to revise criminal discovery, it used the state, in quotes, as a term in a manner that blurs the roles of the prosecutor and the investigator or agencies in providing discovery to the defense. As a result of this ambiguity, the Texas Court of Criminal Appeals in June 2024 held in State v. Heath that a trial court may suppress relevant and incriminating evidence of a defendant's guilt for failing to disclose it upon request, even when a prosecutor had no knowledge that the evidence existed at the time of the initial request. This ruling applies even when the prosecutor acted in good faith and the defendant suffered no prejudice from the non-disclosure. Unfortunately, defense lawyers are now taking advantage of this technicality by not specifically requesting evidence that they know a law enforcement agency has failed to turn over to the prosecutor. Then at trial, the defense can invoke Heath to have it excluded. This gamemanship undermines the integrity of the trial process and core principles of justice. Senate Bill 1124 seeks to rectify the unintended consequences of the Heath decision, which permits the suppression of an inculpatory evidence without requiring a showing of bad faith by the state or any harm to the defense. And I want to emphasize this bill does not apply to exculpatory, impeaching, or mitigating evidence benefiting a defendant, nor does it prevent a court from suppressing evidence in cases of bad faith by the state or incurable prejudice to the defense. The bill clarifies the definition of the state, quote unquote, for discovery purposes, distinguishing the responsibilities of prosecutors from those of law enforcement agencies. The bill also establishes new procedures for requesting discovery, empowers courts to limit overly broad discovery requests, and codifies pre-Heath common law standards governing the suppression of evidence. Many of the elected prosecutors throughout the state have worked carefully on this legislation. Myself and my office has worked with them. Our goal has always been to seek justice, make certain that the Michael Morton Act is being preserved and implemented as intended. This change will ensure that our criminal justice system is weighted equally for both the victims and the accused, but making very sure that all the defendants' rights are protected as established by the Michael Morton Act. With that, I move suspension of the regular order of business.
Senator Menendez, for what purpose?
Questions of the author, Mr. President.
Senator Huffman, do you yield?
Yes, I do.
Senator Huffman, thank you very much. As you know, I'm not an attorney, and I don't have that background that you have or the judicial background experience that you have. But unfortunately, I have an attorney on my staff, and there's a question of concern, and I think you may have addressed it in your layout, but I just want to make sure we get it out and clarify it. One of the concerns is that the court's discretion to limit discovery by limiting evidence or documents necessary in order to prove their case. It's a concern that it could cause difficulty to prove innocence. But I think in your bill layout, you said it excludes the information that could benefit the defendant.
Exactly. Anything that's exculpatory, that means, shows that they're innocent. Mitigating, which could mitigate their guilt or mitigate the punishment, or anything that would, that the prejudice could not be cured by the court and some other remedy, then the bill would not apply to that type of evidence or information.
I've heard from several district attorneys that this is meant, and I think you said it yourself, to level the playing field.
Yes.
And one of my concerns is, could it result in your opinion, do you think this could result in increased false convictions? Because that's a concern for me.
Absolutely not, and I would not sponsor this legislation or write this legislation if I thought there was any chance that we were, leaning towards false convictions. That is not the intent whatsoever. We simply want to, as I said, level the playing field and have these situations where inculpatory, that is, incriminating evidence, is suppressed, even though it's clear that the defense knew about it or the judge has other remedies. For example, the judge could grant a continuance to give the defense time to respond to the fact that now the prosecutor has presented more evidence. So there are many tools in the hands of a judge to ensure that the defendant's rights are protected, but also make sure that the defendant's rights, the victim's rights are protected. For example, one of the prosecutors who testified, I think it was Mr. Dick, I don't remember which county, I think he's from Williamson County, which is ironically the county that the Michael Morton case arose from. And that DA went to jail many years ago for his actions involving in that. But he testified to a case where during the course of the presentation of law enforcement on the stand, they testified about another body cam that he had on that the prosecutor just simply didn't know about it. It was still in the records. It had been preserved, and it was an indecency with child. And within those records were many pictures of child pornography, including with the victim. And the judge suppressed that evidence, even though it had been wholly unknown to anyone that there was, I take that back, it wasn't a body cam, it was they discovered they had taken possession of the defendant's phone. There was another one with body cam evidence. This one dealt with the defendant's phone, and in the phone they found these photos, but that was suppressed. Now, clearly, that was very important evidence because those indecency and those child cases are very difficult to prove anyway, and they're probably about a 50-50 loss on those because many times the evidence just goes to the testimony of the child, which sometimes jurors have a hard time, convicting someone of a very serious offense. But certainly that evidence, hard evidence, unrefutable evidence, was suppressed, and that could never have been, that's not justice. Now, should a continuance have been granted for the defendants, perhaps even a mistrial granted and start all over? There are different remedies that you can take to preserve the defendant's rights, but this Heath decision has led to outcomes that all of us would agree are not justice. And so, yes, it's a balancing act. I understand your concerns, but I have confidence that the system can work through these issues and achieve appropriate and just results.
Well, I think you said it best a second ago when we talk about making sure that we don't convict anyone falsely, but by the same token, we need to protect the victim's rights to get a fair trial so that the person, the perpetrator, can deal with the repercussions of their crime. And so I had been opposed, but I think after conversations with my DA and other DAs and yourself, yes, I think I'm going to be able to support your legislation just because I want to make sure that victims of crime know that they're not alone and that they'll get a fair trial, and that we can't allow for a judge to suppress irrefutable evidence like that, those images.
Yes.
That makes absolutely no sense. And even like you said, they could get a continuance, they could get a new trial, but you can't suppress the evidence. So I thank you for answering my questions.
Thank you, Senator.
Thank you, Mr. President.
Thank you, Senator. Secretary will call the roll on suspension.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell, Cook.
25 ayes, 6 nays. Rules are suspended. Chair lays out on second reading Senate Bill 1124. Secretary, read the caption.
Senate Bill 1124 relating to discovery in a criminal case.
You recognize passage to engrossment.
Passage to engrossment of Senate Bill 1124.
Secretary will call the roll.
Alvarado, Bettencourt, Birdwell.
25 ayes, 6 nays. The bill passed to engrossment. You recognize suspend the constitutional 3-day rule.
So move, Mr. President.
Secretary will call the roll when ready.
Alvarado, Bettencourt, Birdwell.
25 ayes, 6 nays. The rule is suspended. Chair lays out on third reading and final passage Senate Bill 1124. Secretary, read the caption.
Senate Bill 1124 relating to discovery in a criminal case.
You recognize on final.
Move final passage of Senate Bill 1124.
Secretary will call the roll.
Alvarado, Bettencourt, Birdwell.
25 ayes, 6 nays. The bill is finally passed. Thank you.
Thank you.
Senator Birdwell, you're recognized to suspend the regular order of business on committee substitute for Senate Bill 1758.
Thank you, Mr. President. Members, I move to suspend the Senate's regular order of business, take and consider committee substitute for Senate Bill 1758. Members, concerns have been raised regarding the effects of the cement industry and associated aggregate production operations operating in proximity to advanced silicone wafer manufacturers. This conflict is well represented in Grayson County, where there is a pending air permit with the TCEQ for a permanent cement kiln that would include aggregate production operations or a quarry within a few miles from an advanced semiconductor wafer manufacturing facility that is now in operational production. Members, there are only 5 places in the world that produce the advanced semiconductor wafers that are used not only in the microchips of my Ford F-150, but in the Hellfire missiles that seek out our enemies. The wafer manufacturing in Grayson County is the only one of its kind in the United States. The other 4 are in similar areas, are in areas in which either the Chinese Navy has a port or in which the Chinese Navy is circling that island. It is imperative to have a reliable domestic supply chain of wafers so our nation is insulated from such geopolitical conflict. President Trump issued an executive order, EO 14255, just after we heard this bill in committee, that establishes the U.S. Investment Accelerator that puts the full weight of the federal government behind protecting investments consistent with the protection of national security. Know that this wafer manufacturing plant has received a CHIPS Act investment of $380 million in direct funding. With that, let me explain the work we did in the interim and what we are doing with this bill. In accordance with the interim charge given to the Natural Resources and Economic Development Committee by the Lieutenant Governor, we held a hearing to receive testimony on the matter. We learned of the significant investments made by and towards semiconductor wafer manufacturers, as well as the unique wafer manufacturing designs that utilize isolated monolithic platforms cut away from the bedrock deep underground to mitigate vibrations. These wafers must be produced with no vibration. While this advanced mitigation design is effective in protecting the crystal growth process from the surrounding buildings, highways, and businesses, there are real concerns that the vibrations caused by the activity associated with an aggregate production necessary to support a cement kiln. The committee also thoroughly discussed the financial investment by the kiln and quarry operator and the increased need for aggregate products, including cement, due to the significant population and industrial growth of our state that we are experiencing. As this demand continues, industry will continue to receive economic signals to open new operations to compete with foreign imports of cement and to meet the infrastructure needs of our state. In our best effort to find a path forward for both industries to site and operate in Texas, Committee Substitute Senate Bill 1758 creates a pilot program in Grayson County to investigate the possibility of establishing a scientifically based zone within which a semiconductor wafer manufacturing facility and a cement kiln with an associate aggregate production operation could operate without adverse effects on wafer manufacturing. The bill requires a study and a report to be conducted by the University of Texas Bureau of Economic Geology, the BEG, to analyze seismological data related to aggregate production operations and assess the vibrational impact of such operations in relation to nearby wafer manufacturing. For purposes of the pilot program, an initial distance of 10 miles is considered. However, the bill directs BEG to assess distances within and beyond that distance in an effort to bring back to the legislature scientific data that will help us determine whether a semiconductor wafer manufacturing facility requires a protective zone to remain unaffected by seismic activity associated with the limestone, the aggregate production. Because there is a proposed cement operation with just a few miles of the wafer manufacturer, the bill would direct TCEQ to not issue the air permit within that initial 10-mile distance while we obtain the information that we've requested from BEG and are able to address the issue with data-based analysis in the next legislative session. The resulting report is due to the legislature August 1st of 2026, which will allow us to hold an interim hearing and develop legislation for the next regular session that offers the best possibility for both industries to coexist in our state. Lastly, based upon the critical need for aggregate materials and the stationary nature of the natural resources produced for those materials, the bill creates a limitation of liability for cement kilns and aggregate production operations who are in operation now prior to the date of the semiconductor wafer manufacturing facility began operations. Members, the purpose of this bill is to buy time in the coming interim to make a better data-driven decision using the information obtained from this pilot program prior to next legislative session. I'm asking you to take this action instead of making a decision like outright banning the quarry in an area without scientific knowledge, waiting for federal intervention, or to protect national security interests, or to allow the current collision course to continue, which we'd expect to lead to decades of lawsuits and the chilling, if not the halting, of both industries in our state. The data we are seeking does not exist anywhere in the world. Thus, the need to temporarily hold on the air permit to get the answers on the vibration issues so that this new information can be considered when creating new permitting standards for this particular type of activity in proximity to advanced wafer manufacturing. With that, members, subject to your questions, I move suspension, Mr. President.
Senator Gutierrez, for what purpose? I just have a few questions, Mr. President. You yield?
Yes, sir, Mr. President, I yield.
Thank you, Senator Birdwell. How many cement manufacturers would this currently affect?
Okay, say again. I've turned my hearing aids up, so say again.
Well, let's clear up one misconception. This is not a batch plant, correct?
Senator, let me get my other hearing device. When you move your head away from the microphone, so I'm hearing you, but I'm not understanding the exact wording. Stand by. Okay, repeat the question, Senator.
Just to clear up a misconception, is this okay? Is this volume okay?
Perfect.
I was told not to speak too loudly, so I'm going to keep it at this level.
Chewy and I, Senator Hinojosa and I are both hearingly impaired at times, so go ahead. I'm hearing you well.
It's happening to me, sir. Sometimes I find myself raising the volume on the television quite a bit these days.
Yes, sir.
This is not a batch plant, correct?
That's correct. It is a cement kiln where the cement is produced, and the cement production also has an associated quarry.
Okay. And this is in Grayson County, correct?
Correct, Grayson County.
Which is Senator Hagenboo's district, correct?
That's correct.
And the company that you're referring to is it Black Mountain LLC, or what's the name of the manufacturing plant?
Black Mountain is the name of the company that has the permit request for the quarry and kiln operation. Global Wafers is the manufacturer of the advanced silicone wafers.
And Black Mountain applied for this permit about what, 5 years ago?
Somewhere in that range. I don't know the exact date, but somewhere in that range. I can find out if you need me to.
And the wafer company came along when?
When did the wafer company come along? My team tells me they started construction several years ago, but production has already begun.
Okay. Kind of hand in hand, I guess. Black Mountain files 5 years ago, and the wafer company several years ago as well.
That's correct. That's correct. The difference between the two companies, though, is that what Global Wafers is producing did not require a TCEQ air permit the way a cement kiln, actually the rock crusher to a cement kiln, will require an air permit.
But heretofore, there hasn't been an issue between the existence of these two facilities that are a little more than 3 miles away, correct?
I think it's like 3.2, but the existence of the wafer facility is a known today. The cement kiln and the quarry are proposed. They do not exist at this moment. They are proposed, and that's why they're in a TCEQ contested case hearing right now for the rock crusher air permit.
Right. Only known to TCEQ. Was that fair?
I believe that's fair. I didn't learn about the issue until probably a little more than a year ago.
Is there any other source of vibration near the wafer factory?
There are surface vibrations that don't affect the bedrock, and that was what you heard in my layout, that the construction of the plant, the depth at which they've gone to for bedrock, for their vibration mitigation features in the plant are not affected by surface highway. In fact, the cement kiln itself and the rock crusher at surface level, if the permit is granted, do not in fact affect the bedrock. The quarry operation, as either excavation or the severing of the limestone from the quarry, is what might impact vibrationally through the bedrock, might create a seismic activity that affects the impact of the production of the wafers.
Might, according to who?
We don't know. That's why we need BEG to find out, because both entities have given us different answers on the viability of their operations. So part of the reason for having BEG do the study is to get not only unbiased, but scientific data rather than presupposition from the organizations.
Is there a highway next to this wafer manufacturer?
There is.
You think that that highway produces a tremendous amount of vibration?
At the bedrock level, no, but I don't know.
And you're asking this TBEG, the Texas Bureau of Economic Geology, to do a seismic study?
That's correct.
Are you aware that they've already done seismic studies on different geological formations?
They may have done those, but when we spoke to them, they said they'd be more than happy to assist us with this because of the nature of what we're dealing with and the sensitivity of the wafer production. So we're asking them to consider this specific location. There are going to be other studies they've done that will contribute to this. If you heard my layout where I talked about in the bill, we tell them to look at inside the 10-mile perimeter, but they will also look at some of the other studies that they have historical data that's outside the 10-mile perimeter. So I think they will use other studies to supplement what we're asking them to go directly do in Grayson County.
My real concern here, Senator, is that we have a business that has invested millions and millions of dollars into a process with TCEQ, upwards of $50 million. And they're part of the building of America and the building of Texas in cement, you know, you add some aggregate and you make concrete and so forth. And it seems to me like we have a business here that has gone through every hurdle, and people along the way have said, hey, stop for this study, stop for that study, and yet they're still there going through, crossing all the T's and dotting all the I's. And yet here again, we are trying to pass another hurdle, and we're calling it national security. But I'm trying to get my fingers around the science, because, so I checked on my phone, did a little Google search on seismicity science, and I found that there's already a scientific formula. And I further found that the TBEG has already done seismic studies on certain kinds of stone out there. And so I'm wondering why we're delaying yet again another business, whether I like it or not. We're telling another business, you know what, we're going to put the brakes on you. So I'm trying to figure out what this is really about, because there is a science to this. They use a formula. It's called the PPV attenuation formula. Have you heard of that, Senator?
No, I've not. I've left that to the experts at BEG.
It's the general empirical formula used to estimate peak particle velocity as a function of distance. I'm not a scientist, but this formula exists, and I know we're not supposed to use props here, but here it is. You're welcome to come and look at this prop. And I had a number of people, I even went through a few scientists and had them walk me through this. PPV equals peak particle velocity. Are you aware of that?
Only as it relates to muzzle velocity out of a finely tuned firearm.
Yes, sir. Yes, sir. Sadly, we are all aware of that.
Yeah.
The K, because the formula is PPV equals K times R, and then an exponent, a couple of other weird forms inside the formula. The K equals the empirical constant, and that depends on strength, geology, and site conditions. You with me? Still?
Senator, I'm listening to you. I have no scientific background to argue this. BEG is going to conduct the study. That study's been funded in a rider that the budget that was sent to the House and will now go to conference on. I'm going to leave this to the experts, because too much of what we got in the hearing was, in my view, speculation, and therefore we needed to get unbiased scientific data from the state agency that is best qualified to do this.
I don't want to belabor the point, and there's no need to go through the whole line of questions on the science. My point is the science is there, and I had a scientist do the formula for me, and what we knew was the distance at over 4,800 meters, and so they plugged that in. We knew the type of rock formation, so they plugged that in. And they said that in order for that wafer plant to feel any kind of vibration, you would need 38,000 tons of TNT for that plant over there to feel a vibration. And I said, well, give me an equivalency there. They said that is 8 times the Oklahoma City bombing. A lot of young people won't remember what that is, but you and I remember what that is. 8 times Oklahoma City bombing for the folks at the wafer plant to even feel a slight vibration. Are you aware that this science exists already?
No, and if it did exist, why didn't they show up at our interim hearing last summer?
I don't know, but TBEG has done a study on sandstone already, and other agencies have done a study on limestone, which is the formation here. And I further know, if you'll allow me to answer, and I further know that the science is, this is not a hypothesis, this is a known formula to study the attenuation of vibration miles and miles away. And so I'm just trying to, I mean, can't we get that answer tomorrow, next week? Why do we have to wait this long? Why does
I'm glad your sources came to you, but as the guy that's been working this issue as the chairman of the committee, I would find it suspect when your sources don't want to come to me over the last year to tell me this, but yet they're prepared to come to you for the debate on the floor.
Well,
I didn't. Hold on. Let me finish.
I don't know if that's an affront on me or not.
Look, I share your concern, Senator, that we're having to do something that is very difficult and sets a very difficult precedent.
Members, do not talk over each other. Do not yell at each other. You've asked a lot of questions. You may continue if you wish.
I do.
But do so in a gentlemanly way. Thank you.
I have been gentlemanly, sir, but thank you. Senator.
I'm not sure if I have the floor or you do, because my hearing piece came out, so I didn't hear what the governor said.
It's okay.
So I will defer to you.
It's okay. TBEG has studied sandstone, and other agencies across the country have studied limestone. I'm just saying there's a formula for attenuation vibrations. It's science and it exists, but apparently an agency did not tell you this. Is that my understanding?
Everything you're telling me right now is completely new to me.
Okay.
My duty is to charge BEG to go study that location, the specifics of that location, come back with their report so that the legislature can make a better decision next legislative session. If this information was as prevalent as you tell me it is, and I have no reason to doubt that, Senator, why didn't this organization that has this information talk to me about it over a year ago when the Lieutenant Governor gave me the charge?
I don't know, Senator. You'll have to ask them. I don't know.
That's why I'm just putting it on the floor. I'm not asking you.
Yeah, I'm sure that's not an affront to the testimony that I'm putting up here. I don't know.
No, I don't know. Because look, I share the same concern you share that we are being asked to do something, and I'm asking this Senate to do something that is a very unpleasant task, and that is stepping into the regulatory world and saying, hold. But that compelling reason is because of the unique physical plant of the only production facility in the national industrial base that supports our national security structure. Because look, that word gets thrown around a lot. Those wafers are integral to the chips that go into a number of military platforms and other platforms outside of DoD that are both commercial and governmental. That compelling reason is the reason I'm asking for the legislature, the Senate, to consider this aspect, because I'd rather make a better decision next session with scientific data that we have charged BEG to do, rather than argue the data that you've got. I have no reason to doubt the data you've got, other than the fact that whoever had it a year and a half ago should have come to me with it a year and a half ago.
So if your legislation passes, we are to wait. That company that's invested over $50 million to grow our economy, providing over 1,000 jobs in construction, providing over 200 jobs in Grayson County down the road, the company that's dotted all the I's and crossed all the T's through the permitting process, you want them to wait another 2 years?
Potentially 2, potentially longer, depending upon what we find out from the BEG study. But I'd rather come to this legislature next session with scientific data rather than the speculation we've gotten for the last year.
Is there any other concern that we have in the community, any other actors out there, anybody building anything else that we're concerned of? Is it just these folks?
Not to my knowledge at this point.
Not to your knowledge. Okay. Thank you, Mr. President.
Thank you, Senator.
Thank you. Senator Hinojosa, what purpose?
Well, Senator Birdwell, answer a few questions.
Do you yield?
Happy to yield, Mr. President.
Thank you, Senator Birdwell. I don't plan to get into the formula and all the details about limestone. I guess when you talk about a compelling reason, and the compelling reason in this case is national security.
That's correct.
And you explained that there's only one wafer manufacturing site in the United States?
The United States, and it's in Grayson County, yes, sir.
And we don't have any other in this country.
That's correct. The other 4 are all in the Far East and the Pacific Rim.
So we have to depend on foreign countries to be able to deliver, take care of national security that we have in our country.
That is correct, and they're all subject to at this juncture, subject to either Chinese control or Chinese domination.
And that is a very compelling reason why we want to do this study and report before we take any action.
That's correct. I'd rather make an informed decision rather than a speculative one.
Thank you, Senator Birdwell, for answering my question.
Thank you, Senator Host. I appreciate it. Thank you.
Thank you. Senator Hagenbu, what purpose?
To ask the question of the author.
Do you yield?
I yield, Mr. President.
Thanks, Mr. President. Just to try to inform the conversation you and Senator Gutierrez had a little bit, let me ask you a few questions. First off, you said this is the only 300 millimeter wafer plant in the United States at this point, right in time?
That is correct.
Did you know that, and when I was talking to the engineer there, he took me through the plant, he said that they're actually developing the technology for this plant as they build it. So it will be the most advanced wafer technology plant in the world when it's finished, which is basically very close to that right at this point. But were you aware of that?
I was aware it is the advanced silicone wafers, not just a standard wafer, but it's an advanced wafer. I can't define that difference scientifically.
Well, based on what we know, the point is that isn't it true that there is no plant like this in the world to test anything on right now?
That does not have Chinese influence? Absolutely.
Not in the United States, right? Where we could have
But
been.
it's the only one in the United States, yes, sir.
Yeah. Were you aware that when I visited the engineer building it, he said, look, I'm going to describe this to you in layman's terms. It's like hanging a string 40 feet down into a little vat, into a big vat with a little wafer on it. And you have to have 6 days of zero vibration for that thing to grow. And the footers and the construction are the largest I've ever seen. I've been involved in construction for many years, bigger than what you might have seen if you're looking at Cowboy Stadium. The money they put in to ensure, and it goes down, drilled down 40 feet into the bedrock. Right. So they spent a huge amount of money, right, on ensuring there's no vibration in that facility, and it's extremely sensitive to vibration, correct?
That's correct. It has to be produced in a no vibration environment because otherwise the crystallizing will fracture, rendering the wafer ineffective.
So since it's the only one in the United States and is the leading edge technology and it's that sensitive to vibration, and it's this important to national security, really there could not have been a test done at this time that would be we could be sure of, since we didn't have the technology in place until about now, right? Is that a good?
There may be technology, as Senator Gutierrez mentioned, and this is what we're asking BEG to do, is to take their technology and their scientific knowledge, go study this to inform our knowledge in the coming legislative session.
It's possible.
It's
Go ahead. Pardon me, sir.
certainly possible, but part of the testimony we heard was estimates of distance and ranges that I don't think could be scientifically true, because the company had initially given us a 90-mile range, and I'm like, you're talking about shutting down construction in downtown Dallas, my cement kilns and quarries in Ellis County. So as we dug into it, there was not a standard answer from either the quarry industry or the wafer manufacturing. And because each of them had their own perspectives, the only way to get an unbiased scientific ground truth was to have our own state agency that we fund that studies this go do the work to give us that unvarnished, unbiased perspective so that we make an unvarnished, unbiased decision in 2027.
Thank you, Mr. Burwell. Senator Burwell. Thank you, Mr. President.
Thank you, Senator.
Members, the motion is on suspension. Secretary will call the roll.
Alvarado, Betancourt, Birdwell.
24 ayes, 6 nays, 1 present, not voting. Chair lays out on second reading. Committee substitute for Senate Bill 1758. Secretary, read the caption.
Committee substitute Senate Bill 1758 relating to the operation of a cement kiln and the production of aggregates near a semiconductor wafer manufacturing facility.
Do you recognize passage to engrossment?
Move passage to engrossment, Mr. President.
Secretary will call the roll. When ready.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook.
24 ayes, 6 nays. The bill passed to engrossment. You have a 25th vote, I believe.
Thank you, Mr. President.
Make a motion for suspend the constitutional 3-day rule.
So moved, Mr. President.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell.
26 ayes, 5 nays. Rule suspended. Hold 1 moment. Chair lays out in third reading and final passage. Committee substitute for Senate Bill 1758. Secretary, read the caption.
Committee substitute Senate Bill 1758 relating to the operation of a cement kiln and the production of aggregates near a semiconductor wafer manufacturing facility.
Senator Hagenbu, what purpose?
Thank you, Mr. President. Speak on the bill.
You're recognized.
Senator Birdwell, I want to thank you for all the effort you put into this bill. It's vitally important. It's vitally important for, I would say, at least 3 reasons. One, for our nation, for national security, to have the wafer and the semiconductor infrastructure that we need for our future. Secondly, to protect the taxpayer investment. Hundreds of millions, if not billions of dollars of tax incentives will have been invested by the taxpayers at the national, state, and the local level, the Grayson County level and at the Sherman level. We need the taxpayers to get the return on investment, and this protects that. And thirdly, it protects thousands of high-paying jobs in the Grayson County area that are assured if these plants are completed and are able to operate successfully. So Senator Birdwell, you put a great deal of effort into this. I appreciate all the thought you put into it to try to accomplish those benefits while protecting and limiting the impact in a small area to our very, very important cement and concrete industry, which we need, of course, for this state to continue to grow. So I want to thank you, Senator Birdwell, for that. And members, I just want to strongly urge you to support this bill. Thank you. Thank you, Mr. President.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell.
24 ayes, 6 nays, and 1 present not voting. The bill is finally passed. Thank you.
Thank you, Mr. President. Members.
Senator Colcourse, you're recognized. Suspend the regular order of business. Committee substitute for Senate Bill 2078.
Thank you, Mr. President and members. I move to suspend the Senate's regular order of business and take up and consider at this time committee substitute to Senate Bill 2078. Members, this bill is a result of constituent outcry from Senate District 18, in particular Lee County. Last December, TCEQ informed the county that a new compost facility was being planned on a 60-acre property near Lincoln. The plans for this facility had it near Yawa Creek, which feeds into Lake Somerville, which is the region's source of drinking water. Several local city councils and commissioners court throughout the region passed ordinances encouraging that this facility not proceed. Additionally, the LLC that was supposed to run the composting facility has had a history of tens of thousands of dollars in fines from the TCEQ because of public nuisance for their smell when operating the facility in Austin. The bill makes it so that entities may not deposit at a composting facility in a county that does not have a municipality with a food waste ordinance, meaning if a county has a city that mandates this composting, that mandated food waste may not leave the county. This is applicable only to the mandated food waste. For each infraction, a civil penalty of $1,000 in violation may be recovered by the Attorney General. I will offer an amendment to clarify a drafting error. That amendment makes it crystal clear that this bill only impacts a municipality that adopts a universal recycling ordinance. The bill is about certainly the outcry that we saw from thousands, literally thousands of petitions that we received from our community. And so, members, with that, I move to suspend the regular order of business.
Members, any objection? Hearing none, the rules are suspended. Oh, we need to call the roll. There were a few objections. Secretary, call the roll.
Alvarado, Betancourt, Birdwell.
27 ayes, 4 nays. The rules suspended. Chair lays out on second reading. Committee substitute for Senate Bill 2078. Secretary, read the caption.
Committee substitute Senate Bill 2078 relating to regulation of composting in certain counties.
You are of the following amendment. Secretary will read the amendment.
Floor amendment number 1 by Colcourse.
Senator Colcourse.
Thank you, Mr. President. I am offering this amendment to clean up a drafting error that accidentally included the entire county of a municipality with a mandate. This amendment removes the phrase "a county that contains." This is a correction that saves other cities or programs who do not have a mandate from being implicated with this bill. I move adoption.
Any objection? Hearing none, the amendment is adopted. You recognize passage on engrossment.
Thank you, Mr. President. I move passage to engrossment.
Secretary will call the roll.
Alvarado, Betancourt,
27
Birdwell.
ayes, 4 nays. The bill passed to engrossment. You recognize to suspend the constitutional 3-day rule.
So moved, Mr. President.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell.
27 ayes, 4 nays. The bill is passed. The rules are suspended, rather. Chair now lays out on third reading and final passage committee substitute for Senate Bill 2078. Secretary will read the caption.
Committee substitute Senate Bill 2078 relating to the regulation of composting in certain counties.
You're recognized on final.
I move final passage of committee substitute Senate Bill 2078.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell.
27 ayes, 4 nays. The bill is finally passed. Thank you.
Thank you, Mr. President.
Senator Campbell, you're recognized for a motion to suspend the regular order of business on Senate Bill 33.
Thank you, Mr. President. Members, Senate Bill 22 in the 86th regular session said no taxpayer dollars can be used for abortion. This bill, SB 33, ensures taxpayer funds are not used to indirectly support or facilitate out-of-state abortion services by explicitly prohibiting governmental transactions with abortion-assisted entities. Thank you, Mr. President. I move to suspend the regular order of business and take up.
Senator Eckhart, for what purpose?
To ask questions of the bill's author.
Senator Campbell, do you yield?
I do.
Senator, this bill is designed to prevent municipalities from furnishing any assistance to pregnant people in travel, correct?
This bill is to prevent this bill is to prevent taxpayer dollars from being used by a governmental entity to assist a woman seeking an abortion out of state.
So this would prevent any kind of local government from furnishing the means to access an abortion that's not covered by the emergency exception.
Correct. This does not apply to any emergency. This applies for assistance going out of state to seek an abortion.
So irrespective of what governmental entity it is, any governmental entity would not be able to furnish the means for procuring an abortion knowing that those funds would be used to procure for the purposes of getting an abortion, correct?
That is correct.
So why not just pursue this under Article 4512.2 of Vernon's civil statutes?
I don't really know. I think it's easy to put it in the bill, just like it is. It says it's illegal. You can't do it.
Thank you for answering my questions.
Yes, ma'am.
Senator Campbell moves suspension of the regular order of business on Senate Bill 33. There is objection. Secretary will call the roll.
Alvarado, Betancourt, Bardwell, Blanco, Campbell.
22 ayes, 9 nays. The rules are suspended. Chair lays out on second reading Senate Bill 33. The Secretary read the caption.
Senate Bill 33 relating to certain prohibited transactions and logistical support between a governmental entity and an abortion assistance entity or abortion provider for the procurement of an abortion or related services.
Following amendment, Secretary read the amendment.
Floor Amendment number 1 by Campbell.
Senator Campbell, you recognize.
Thank you, Mr. President. This is just clarifying language that governmental entities, once again, may not enter into transactions with abortion assistant entities for the purpose of providing an abortion or abortion assistance.
The question is on the adoption. Floor Amendment number 1. Is there objection? Hearing none, the amendment is adopted. Senator Campbell, you recognize for a motion.
I move passage to engrossment.
Senator Campbell moves passage to engrossment. There is objection. The Secretary will call the roll.
Alvarado, Betancourt, Bardwell, Blanco, Campbell, Cook, Creighton, Eckhart, Flores.
22 ayes and 9 nays. Bill is passed to engrossment and will hold there.
Thank you, Mr. President. Thank you, members.
Senator Sparks, you are recognized for a motion to suspend the regular order of business on committee substitute for Senate Bill 34.
Thank you, Mr. President. Members, I move this time to suspend the regular order of business in order to take up and consider committee substitute to Senate Bill 34. The 2024 Panhandle wildfires, the largest in Texas history, burned over 1 million acres, causing significant destruction to ranches, homes, and livestock. Wildfires devastate local communities, destroy property, and strain emergency response systems. In response to that, the Texas House Investigative Committee on Panhandle Wildfires examined the factors contributing to the intensity and destructive nature of the fires, including underfunding of the Texas Rural Volunteer Fire Department Assistance Program. With an annual cap of $30 million and a grant request often exceeding $43 million, the program faces a $22 million biennial shortfall, leaving the fire departments with only partial funding for critical equipment. Despite the heroic efforts of the volunteer firefighters, response times were hindered by a lack of timely air support, poor communication between agencies and responders, largely due to incompatible equipment. Testimony from the hearings indicated that the total economic loss to the Panhandle, its economy, and economies it feeds may ultimately exceed over $1 billion. The committee substitute to Senate Bill 34 enhances wildfire preparedness, prevention, and mitigation for the state through several measures and ensures that Texas is better equipped to protect communities, wildlife, and our economy from future wildfire devastation. First, it requires a comprehensive study to be conducted by Texas A&M Forest Service and West Texas A&M University. This study focuses on mitigating wildfire risks in Texas. It'll elevate the potential impact of wildfires. It will evaluate potential impact on wildfires on residents, property, businesses, and the state's ecology using data from various state agencies to ensure a thorough and informed approach. The bill also requires Texas A&M Forest Service to create and maintain a statewide database of firefighting equipment, which will be accessible to all fire departments and updated annually, improving coordination and planning. Then additionally, it increases the funding cap for Rural Volunteer Fire Department Assistance Fund from $30 million to $40 million, with 10% of the funds designated for high-risk wildfire areas. This will ensure volunteer fire departments, which cover more than 85% of the state land, to receive the necessary resources. Lastly, the bill clarifies a memorandum of understanding that requires the Railroad Commission to notify the Public Utility Commission about concerning situations at energy and electricity facilities. Texas must lead the way in addressing this crisis. By strengthening preparedness, response, and prevention efforts, we can protect Texas while setting a national example for future wildfire resistance. We also have an amendment as well.
Senator Sparks moves suspension of the regular order of business on committee substitute for Senate Bill 34. Is there objection? Hearing none. The rules are suspended. Chair lays out on second reading. Committee substitute for Senate Bill 34. The Secretary read the caption.
Committee substitute Senate Bill 34 relating to the preparation for and the prevention, management, and potential effects of wildfires and to emergency communications in the
Following
state.
amendment, Secretary read the amendment.
Floor amendment number 1 by Sparks.
Senator Sparks, you're recognized. Speak to the amendment.
Thank you, Mr. President. The amendment simply creates a more structured process for addressing unsafe electrical conditions at oil and gas well sites in Texas. With that, Mr. President, I move adoption. Pardon me, I'm getting ahead of myself.
The question is on the adoption of amendment number 1. Is there objection? Hearing none. Amendment is adopted. Senator Sparks, you're recognized for a motion.
Thank you, Mr. President. I move to engrossment.
Senator Sparks moves passage to engrossment. Is there objection? Hearing none. The bill is passed to engrossment. Senator Sparks, you're recognized for a motion to suspend the constitutional 3-day rule.
So moved.
Senator Sparks moves suspension of the 3-day rule. Secretary will call the roll.
Alvarado, Betancourt, Bardwell, Blanco, Campbell.
31 ayes, 0 nays. Rules are suspended. Chair lays out on third reading and final passage of committee substitute Senate Bill 34. Secretary read the caption.
Committee substitute Senate Bill 34 relating to the preparation for and the prevention, management, and potential effects of wildfires.
Senator Sparks, you're recognized for a motion.
Mr. President, I move final passage of committee substitute for Senate Bill 34.
Senator Sparks moves final passage of committee substitute for Senate Bill 34. The Secretary will call the roll.
Alvarado, Betancourt, Bardwell, Blanco, Campbell.
31 ayes, 0 nays. The bill is finally passed. Congratulations.
Thank you, Mr. President. Thank you, members.
Senator King, you're recognized for a motion to suspend the regular order of business on Senate Bill 1208.
Thank you, Mr. President. Members, there's been an incredible rise in incidents across the state of individuals obstructing peace officers, emergency medical personnel, and public officials from safely performing their duties. The behavior raises concerns about law enforcement safety and effectiveness, and also their ability to protect the public. When an individual interferes, and we're not talking about just speech here, we're talking about direct interference, when they disrupt or impede a peace officer's work, it hinders the officer's ability to maintain order and to respond to the emergencies that they're attempting to respond to. It is crucial to address this issue to allow our first responders to serve their communities safely. In Tarrant County, I know of one individual who's been arrested 8 times for obstructing peace officers responding to emergencies. SB 1208 seeks to deter this behavior, which has a low criminal penalty now, by increasing the penalty for the offense of interference with a peace officer's or a public official's public duties. It increases it from a Class B misdemeanor to a state jail felony. And with that, I would move to suspend the regular order of business.
Senator Eckhart, for what purpose?
Should I ask questions of the author?
Senator King, do you yield?
Certainly.
Senator, are you aware of the Antonio Buehler case that went all the way to the U.S. Supreme Court?
Tell me the facts if it rings a...
Antonio Buehler was a combat veteran who also was an Ivy League graduate, I believe in economics. And he began recording activity of police officers on public streets in downtown Austin. Are you aware of his case?
You know, I may be. I've read a number of the cases. And in fact, if you go to just YouTube channel, you can see, because a lot of them record their activities when they're doing this, and then they are paid to post them. So there's a lot of examples on YouTube. In fact, they use that for law enforcement training now. So I don't know all the specific details.
Antonio Buehler was at a gas station when he saw a police officer arresting a woman, and he started videotaping the arrest. He was arrested himself for interfering with the lawful order of a police officer. His case was later dismissed. In fact, the federal court found that he had a right, that citizens have a right to, for instance, record the behavior of government officials in their, in their open capacity. Do you agree with that right?
Yes, and in fact, the bill very specifically does not interfere with free speech. These are not activities such as that sounds like it was, where the person did not commit the crime of interference. This addresses raising the penalty where someone was rightfully convicted of of committing that offense. The case you described, apparently they did not commit the offense.
So Mr. Buehler, I believe, was arrested 5 more subsequent times for videoing police activity on public streets. And he appealed, but because his criminal cases were still pending, his case was dismissed and never reached the U.S. Supreme Court. His civil case.
So I'm sorry what the question, I think what you're asking is, do I recognize that someone can be exercising their free speech rights? Someone can be videoing officers, or someone operating an emergency medical, vehicle, or other public officials doing their job. Can they video those? Can they yell across the street at them? Can they do things like that? Yes, they can do that without even coming near violating the interference law. The interference law is very specific, and it's an aggressive action that literally prohibits the officer or the emergency medical personnel or the firefighter, whoever it may be, from performing their duties. And in fact, in many cases, it not only prevents them from performing their duties, but when you're trying to intervene in a dangerous situation, maybe it's a robbery, maybe it's a drug bust, maybe it's a gang fight, whatever it is, and you're trying to calm and deal with that very dangerous situation, and you have the risk of the need that you may need to use force of some nature, and if you have a third party that's directly interfering in that to the point that you cannot perform your duties, it not only puts the officer or the firefighter or the medical personnel at risk, but it puts the people at risk of something going wrong in that incident that the officers could have prevented from occurring. So yes, free speech is protected just like it is under the current statute. The statute has not changed. All we're doing is saying there's such an incredible rise in the number of these incidents, a lot of which people are paid for doing. And there's such an incredible rise that a Class B misdemeanor is not acting, and it's not an enhanceable Class B misdemeanor. It can't be bumped up to Class A on the second or third time. That's why the one person in Tarrant County has had 8 arrests for that, and yet none of them can be enhanced. And so what it's doing is taking it from a maximum penalty of 180 days for a Class B misdemeanor to a state jail felony where it has a minimum of 180 days, maximum of up to 2 years. But of course, those can have deferred adjudication and also probation and other things, community supervision prior to going to jail.
So it's very interesting that you raised that. It's true, it's not enhanceable as a misdemeanor. So Mr. Bueller was repeatedly arrested for a misdemeanor because the cops were mad that he kept recording them. So they eventually arrested him for assault of a peace officer alleging that he had spit on them so that they could get a state jail felony and thereby have his federal civil rights lawsuit kicked out because he had a pending state jail felony. And the court ruled that his state jail felony had to be resolved before he could bring his case back. Are you aware of that?
I'm not aware of that specific case, the facts in it, no.
So under existing case law, there is a standing provision that if a person has a state jail felony, they can't get their civil rights reviewed until that case is resolved.
And what would be wrong with that?
It means that in what is a misdemeanor interference, will now be a state jail felony interference.
Correct.
And it needs to be resolved at the trial court level before you can bring a civil action for having your rights violated.
You're right. I don't know all the details of that case, and it sounds like it was actually several cases that went way up an appellate side, maybe on the criminal, maybe on a civil side as well. What I do know is this, is that you talk to any police officer, any firefighter, any emergency medical personnel, anywhere in the state of Texas, and they will tell you that this problem is increasing dramatically, as I mentioned, some people are actually getting paid for the more postings they do, they get a following, that type of thing, but it's increasing, it's placing not only our government personnel, our first responders in danger, but it's placing the people they're trying to deal with in even greater danger. And when you have these third-party interferences. So again, I don't know of that case. I do know of hundreds of others of incidents that are occurring across our state, and it increases, and it's a bad situation, and the Class B misdemeanor is obviously not deterring it, so the only common sense thing you can do is bump up the punishment and hope that that begins to be a deterrent. The other nice thing about bumping it up, when you get to a state jail felony, you had a lot of other options that you can do to try to deal with that person, from community supervision to a number of other things that may not be available for a simple Class B, non-enhanceable offense.
You think community supervision isn't available for a Class B?
No, I know it can be, but other things aren't necessarily available that are available with parole and probation and other things.
So are you aware of a 17-year-old homeschooled child in Wichita Falls who is going into public buildings like their library, their post office, and their local federal court and videotaping?
Not aware of that homeschool student.
Are you aware that that 17-year-old was recently detained for being in a federal courthouse recording? Do you think he should be vulnerable to a state jail felony?
Don't know the facts, but it may have been necessary to detain him. He may have been acting suspiciously. They may have been concerned he was doing something that was going to place the public at risk. I don't have any idea of those facts.
I'll send you the article.
Okay, great. What I do know is you talk to any law enforcement officer in the state of Texas, and they will tell you that people's lives, including their own, are being endangered at an ever-increasing rate, and whatever we're doing today with Class B misdemeanors is not correcting the problem.
Can a peace officer arrest on a Class B misdemeanor?
Yes.
So a peace officer in the moment can detain, arrest, and have taken to booking a person who is engaged in interfering with the lawful order of a peace officer.
Yes, and I mentioned
whether it's a misdemeanor or a state jail
And I mentioned that
felony.
one person in Tarrant County alone who's been arrested 8 times for what were very serious interference circumstances.
8 times, 180 days consecutive?
Again, all I can tell you is it is a problem that is ever increasing. It is placing law enforcement, it is placing firefighters, it is placing emergency medical personnel, and it is placing the public in grave jeopardy. And what we are doing today is not working. And so the effort is, and this was actually brought to me by the Tarrant County DA's office, the effort is let's try enhancing the penalty and see if with the options of a state jail felony, the concern that will bring of having a higher penalty, but also the other things you can do to intervene at that level, and see if we can't make a dent in this and get it stopped.
Well, just for the record, on one of those arrests of Antonio Bueller, it was Justin Berry who arrested him. Thank you for answering my questions.
Senator West, for what purpose?
Question of the author.
Senator King, do you yield?
Certainly.
I appreciated the exchange between you and Senator Eckhart. I just want to make certain that we're real clear on this, because if for some reason a citizen is arrested because they are taping an incident that an officer is involved in, that's not interfering with that officer, correct?
That's correct. In fact, there is a defense to prosecution, which functions like an affirmative defense, as you know, a defense to prosecution to the statute that says that conduct intended to warn a person operating motor vehicle of the presence of a peace officer is not a violation, nor is the interruption, disruption, impediment, or interference consisting only of speech. So speech alone does not violate the offense of interference.
Okay, let's make sure, again, speech alone does not violate. So do you consider, if I were to say that you're a police officer and you're engaged in arresting someone and I had my video camera out?
Well, the penal code actual wording says for interference with public duties, a person commits an offense if the person with criminal negligence, as the mens rea, interrupts, disrupts, impedes, or otherwise interferes with a peace officer while the peace officer is performing a duty or exercising authority. And again, it has that affirmative defense that it cannot be
So you don't
speech.
consider, if I'm videotaping, is that disrupting, is that violating that statute in any way?
Mere videotaping would not violate the statute.
Okay, so if for some reason this issue comes up and a citizen is arrested by a police officer for doing that, I want to make certain that we take this conversation and put it on a journal so someone would be able to use that as what your intent is as it relates to this particular offense. So you're okay with that, aren't you?
Yes, I agree with that, but I want to clarify that I'm not changing the interference statute. So the mens rea and the actus reus, the mental state and the criminal act are not being changed that together constitute the offense.
What you're doing,
All I'm doing is enhancing
changing the penalty. You're changing the penalty. And
Yes.
so from that vantage point, I want to make certain it's not your intent in changing the penalty. To make certain that if a citizen is videotaping a police officer that's arresting someone, that that's not considered to be interfering with the police officer and in violation of this particular statute. So the person would be then eligible for a state jail felony. That's what I'm trying to make certain of.
Right, and you are correct in saying that I'm not doing anything that changes the statute itself, the mens rea or the actus reus. I am enhancing the penalty, and I agree with you that under the statute, as it is now and as it would be if the bill passes, that simply videotaping an officer or simply speaking to an officer does not constitute, under the statute, interference with someone performing public duties.
Thank you, Senator.
Senator Hinojosa of Hidalgo, for what purpose?
Will Senator King yield?
King will yield?
Yes, certainly.
Thank you, Mr. President. And, Senator King, we had this bill come out of the Criminal Justice Committee, and we heard quite a bit of testimony. And from the testimony and your bill itself, it is very clear that a citizen can videotape a police officer.
Absolutely.
As long as they don't interfere with the duty of the police officer. And in testimony that we heard, somebody like Mr. Bueller, for example, they were, quite frankly, in the face of the police officer. And they were harassing the police officer, even when they were told to please step away. And those are the type of cases we're trying to address with Senate Bill 1208. Is that correct?
That's exactly correct. And again, if you look at some of the videos that are on YouTube that have been posted with this, that the law enforcement now uses in training, this is a very aggressive instance of someone getting in the face of, getting in the middle of that activity. They're searching someone, they're searching a vehicle, and preventing that officer from doing their job. It's a very aggressive intervention. It's not just standing 20 feet away yelling at them, and it's certainly not just holding a camera and video and the officer doing the search or whatever they're doing.
And the Class B misdemeanor right now just has not been a deterrence in keeping some of those very aggressive people that are more interested in your-face type of tactics against police.
Yes, and sometimes things like that devolve into someone having to be arrested, and it becomes a resisting arrest, and it gets out of hand. The intent here is that increasing the penalty will be an effort, hopefully it works, to deter people from doing this, because apparently right now they're just not really worried about a Class B misdemeanor.
And many times, right after they get arrested, they're let out, and they'll be right back in the street again, harassing and interfering with other police officers.
That's right, because the bonding process and everything involving a felony versus involving a Class B misdemeanor is completely different.
Thank you, Senator King, for answering my
question.
questions.
Thank you, sir.
Senator King moves suspension of the regular order of business on Senate Bill 1208. There is objection. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell,
26 ayes, 5 nays. Rules are suspended. Chair lays out on second reading Senate Bill 1208. Secretary will read the caption.
Senate Bill 1208 relating to increasing the criminal penalty for the offense of interference with public duties.
Senator King, you're recognized for a motion.
Move passage to engrossment.
Senator King moves passage to engrossment. There is objection. The Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook, Creighton, Eckhart, Flores.
There be 26 ayes and 5 nays. The bill is passed to engrossment. Senator King, you're recognized for a motion to suspend the constitutional 3-day rule.
So move.
Senator King moves suspension of the 3-day rule. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell.
26 ayes, 5 nays. The rules are suspended. Chair lays out on third reading and final passage Senate Bill 1208. Senator King, you recognized. The Secretary will read the caption.
Senate Bill 1208 relating to increasing the criminal penalty for the offense of interference with public duties.
Senator King, you're recognized for a motion.
Move final passage.
Senator King moves final passage of Senate Bill 1208. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook, Creighton. 26
ayes, 5 nays. Bill is finally passed. Congratulations, Senator.
Thank you, Mr. President. Thank you, members.
Senator Nichols, you're recognized for a motion to suspend the regular order of business on Senate Bill 1030.
Thank you, Mr. President. I move suspending the regular order of business on Senate Bill 1030. Members, 1030 removes the maintenance, repair, and overhaul tax for general aviation. This will make Texas competitive with neighboring states and will help the general aviation industry continue to flourish. A more competitive sales tax policy could yield millions in economic activity over a period of time as a result. And with that, I move suspending the regular order of business on Senate Bill 1030.
Senator Nichols moves suspension of the regular order of business on Senate Bill 1030. There is objection. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook.
28 ayes, 3 nays. The rules are suspended. Chair lays out on second reading Senate Bill 1030. The Secretary will read the caption.
Senate Bill 1030, relating to the exemption from sales and use taxes for certain aircraft components and other property required for normal aircraft operations.
Senator Nichols, you're recognized for a motion.
I move passage to engrossment of Senate Bill 1030.
Senator Nichols moves passage to engrossment. There is objection. The Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell.
28 ayes, 3 nays. The bill is passed to engrossment. Senator Nichols, you recognized for a motion to suspend the constitutional 3-day rule.
I move suspend the 3-day rule.
Senator Nichols moves suspension of the 3-day rule. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell.
28 ayes, 3 nays. The rules are suspended. Chair lays out on third reading final passage Senate Bill 1030. The Secretary will read the caption.
Senate Bill 1030, relating to the exemption from sales and use taxes for certain aircraft components and other property required for normal aircraft operations.
Senator Nichols, you're recognized for a motion.
I move final passage of Senate Bill 1030.
Senator Nichols moves final passage of Senate Bill 1030. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell.
28 ayes, 3 nays. Bill is finally passed. Congratulations.
Thank you, Mr. President and members.
Senator Betancourt, you're recognized for a motion to suspend the regular order of business on Senate Bill 505.
Thank you, Mr. President and members. Currently, there's no mechanism requiring elections office to explain an irregularity to those who are eminently involved in the election. A candidate, election worker, or party, chair, proponent, or opponent of a measure can send in a request, but there's no requirement that the elections office respond. Senate Bill 505 is a vehicle for those to get actively involved, to get answers and shine light on any issue that to get election regularity solved, but also talked about. If the Secretary of State finds a violation, the SOS can require a county to remedy the situation and assess a penalty of $500 a day. Additionally, in severe situations, there can be a conservator appointed or oversee elections. But I have a tendency to think that if people ask questions and get answers, we're not going to ever get to that level. And with that, I move move the suspension of the regular order of business and take up and consider Senate Bill 505.
Senator Betancourt moves suspension of the regular order of business on Senate Bill 505. There is objection. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell.
20 ayes, 11 nays. The rules are suspended. Chair lays out on second reading Senate Bill 505. Secretary read the caption.
Senate Bill 505, relating to processes to address election irregularities.
Senator Betancourt, you're recognized for a motion.
Thank you, Mr. President. I move passage of Senate Bill 505 to engrossment.
Senator Betancourt moves passage to engrossment. There is objection. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook.
20 ayes, 11 nays. Bill is passed to engrossment. Will hold there.
Thank you, Mr. President and members.
Senator Schwertner, you're recognized for a motion to suspend the regular order of business on committee substitute for Senate Bill 2411.
Thank you, Mr. President. Members, I move to suspend the Senate's regular order of business table and consider at this time the committee substitute Senate Bill 2411. Members, this bill is a biennial update to the Texas Business Organizations Code that the legislature passes each session to ensure the code remains current. The updates in this bill are derived from collaborative work by the State Bar's Business Organizations Code Drafting Committee, developed in coordination with the Texas Secretary of State. As in previous sessions, the goal of this bill is to strengthen the legal framework governing business entities in Texas and help maintain our state's continued competitiveness and business-friendly environment. There will be one amendment that clarifies that filings to the Secretary of State's office can be done by any measure acceptable by the office rather than just by fax. Mr. President, I move suspension of the regular order of business.
Senator Schwertner moves suspension of the regular order of business on committee substitute for Senate Bill 2411. Is there objection? Hearing none, rules are suspended. Chair lays out on second reading committee substitute for Senate Bill 2411. Secretary, read the caption.
Committee substitute Senate Bill 2411 relating to business organizations.
There is an amendment. Secretary, read the amendment.
Floor amendment number 1 by Schwertner.
Senator Schwertner, you're recognized.
This amendment eliminates the statutory requirement that the office must accept business filings by fax. Instead, allows the office to prescribe the methods by which the business filings are accepted. Move adoption of floor amendment number 1.
Questions on the adoption of floor amendment number 1. Is there any objection? Hearing none, the amendment is adopted. Senator Schwertner, you recognized for a motion.
So moved to passage to engrossment. Committee substitute Senate Bill 2411.
Senator Schwertner moves passage to engrossment. Is there objection? Hearing none, the bill is passed to engrossment. Senator Schwertner, you recognized for a motion to suspend the constitutional 3-day rule.
So moved, Mr. President.
Senator Schwertner moves suspension of the 3-day rule. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook.
30 ayes, 1 nay. The rules are suspended. Chair lays out on third reading final passage of committee substitute for Senate Bill 2411. Secretary, read the caption.
Committee substitute Senate Bill 2411 relating to business organizations.
Senator Schwertner, you recognized for a motion.
Mr. President, I move final passage of committee substitute Senate Bill 2411.
Senator Schwertner moves final passage of committee substitute for Senate Bill 2411. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell,
30
Cook.
ayes, 1 nay. The bill is finally passed. Congratulations, Senator.
Thank you, Mr. President. And
Senator Hughes, you are recognized for a motion to suspend the regular order of business on committee substitute for Senate Bill 1333.
Thank you, Mr. President. I move to suspend the Senate's regular order of business to take up and consider at this time Senate Bill 1333. Senators, this is about squatters, a real crisis affecting Texas and really the whole country. Now, we passed Senator Betancourt's bill on this topic. His was a much broader bill that is on its way to the House. This bill affects only folks who have moved onto property without permission. So this is not about tenants who have overstayed or tenants who haven't paid their rent. That's not what this bill is about. It's much narrower. It is about people that move onto property without any consent, no lease, no permission. They just move on, unlawfully occupying the home and stay there. A 2024 survey says that Dallas ranks among the top cities nationwide with this problem, with over 450 reported cases. So Texas is seeing more than its share. Right now, squatters can be removed for trespassing, but they must be evicted by law enforcement with a valid court order. The existing process for removing squatters and reclaiming property can be time-consuming and financially burdensome, and there are safety concerns as well. Again, the eviction process is different, and so that's why this bill is important. Sometimes when the law enforcement is called, they come in and say, oh, this is a civil matter, we can't get involved in this. This bill will provide a tool for the rightful owners of property to deal with squatters, folks who have moved onto the property, moved into the house without consent. Homeowners are affected by this. Obviously, they're still responsible for the economic obligations, paying taxes, while someone else occupies the home. They're in a precarious position with liability for things that happen there. And often, once homeowners get their homes back, they find them in disarray or unlivable conditions with significant repair costs and further financial burdens. These issues are getting more complex and escalating. This bill provides an elegant tool for homeowners to deal with folks who have no legal right and never did have a legal right to be on the property. And I move suspension.
Senator Hughes moves suspension of the regular order of business on committee substitute for Senate Bill 1333. There is objection. The Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell, Cook, Creighton.
27 ayes, 4 nays. Rules are suspended. Chair lays out on second reading. Committee substitute Senate Bill 1333. The Secretary read the caption.
Committee substitute Senate Bill 1333 relating to the unauthorized entry, occupancy, sale, rental, lease, advertisement for sale, rental, or lease or conveyance of real property.
Senator Hughes, you're recognized for a motion.
I move passage to engrossment.
Senator Hughes moves passage to engrossment. There is objection. Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco.
27 ayes, 4 nays. Bill is passed to engrossment. Senator Hughes, you recognized for a motion to suspend the constitutional 3-day rule.
Mr. President, I move to suspend the constitutional rule that bills be read on 3 several days.
Senator Hughes moves suspension of the 3-day rule. The Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell, Cook, Creighton.
27 ayes, 4 nays. Rules are suspended. Chair lays out on third reading, final passage. Committee substitute Senate Bill 1333. The Secretary read the caption.
Committee substitute Senate Bill 1333 relating to the unauthorized entry, occupancy, sale, rental, lease, advertisement for sale, rental, or lease or conveyance of real property.
Senator Hughes, you're recognized for a motion.
Mr. President, I move final passage.
Senator Hughes moves final passage of committee substitute Senate Bill 1333. The Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell.
27 ayes, 4 nays. Bill is finally passed. Congratulations.
Thank you, Mr. President, and thank you, members.
Well, Senator Bettencourt, you are recognized for a motion to suspend the regular order of business on Senate Bill 1541.
Thank you, Mr. President. And members, after November election, in even-numbered years, the Secretary of State is required to select 4 counties at random. There's 2 large counties, effectively 2 small counties, and a county selected in the most recent audit cycle may not be selected in the current cycle. Concerns were raised during the interim by the Secretary of State's office about what they can do with their randomized post-election audits. Senate Bill 1541 simply allows the SOS to continue to monitor elections for the next year and coordinate with local election officials to develop a plan that help may remedy any issues. And with that, I move suspension of the regular order of business to take up and consider Senate Bill 1541.
Senator Bettencourt moves suspension of the regular order of business on Senate Bill 1541. There is objection. Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell.
23 ayes, 8 nays. Rules are suspended. Chair lays out on second reading Senate Bill 1541. The Secretary will read the caption.
Senate Bill 1541 relating to state oversight of county elections following a county election audit.
Senator Bettencourt, you're recognized for a motion.
Thank you, Mr. President. I move passage to engrossment of Senate Bill 1541.
Senator Bettencourt moves passage to engrossment. There is objection. The Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook.
23 ayes, 8 nays. The bill is passed to engrossment. We'll hold right there. Senator Hughes, you recognize for a motion to suspend the regular order of business on Senate Bill 310.
Thank you, Mr. President. I move to suspend the Senate's regular order of business to take up and consider at this time Senate Bill 310. Members, this is a bill that the Senate passed last session about ranked choice voting. This ban was passed in a bipartisan manner in the 88th legislature. Some of you may not have heard of ranked choice voting yet, or maybe until that debate, but here's how it is supposed to work. It's a confusing system. It's touted as a reform. It's being pushed mostly in large cities, but also some states, and it fundamentally changes the election process. It has the effect of disenfranchising voters, and it allows marginal candidates that do not have the support of a majority of voters to be elected. That's what it does in effect. 14 states have already banned ranked choice voting. 2 more states have passed bills that are awaiting signatures from their governors. But we have seen ranked choice voting pushed already in Austin and in Dallas. Now, back in 2001, our Secretary of State, Henry Cuellar, wrote an election law opinion advising that ranked choice voting is illegal in Texas. And when Governor Abbott was Attorney General, he issued a 2003 opinion agreeing with that analysis. Of course, these are right, but those opinions, as we know, are not legally binding. They are persuasive authority. They are not controlling authority. And so let's nip this in the bud before it takes root in Texas. The bottom line is evidence has shown this is confusing to voters. Voters normally are asked to rank 1 through 5, but rank only 1. And when you choose just the first candidate and go home, once they go through the ranked choice voting process, once your candidate is out, your vote does not count on future rounds. Each year since this has been in place, we've had situations around the country where someone under ranked choice voting is certified as the winner, and then a watchdog does some work and finds out, sorry, we certified the wrong winner, and they have to go back and give the office to someone else. It's confusing, it's expensive, it's anti-democratic. We don't need it in Texas, and so I move suspension of the regular order of business, Senate Bill 310.
Senator Hughes moves suspension of the regular order of business on Senate Bill 310. There is objection. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco,
22
Campbell.
ayes, 9 nays. Rules are suspended. Chair lays out on second reading Senate Bill 310. Secretary, read the caption.
Senate Bill 310, relating to the determination of a majority vote in certain elections.
Senator Hughes, you recognize for a motion.
Mr. President, move passage to engrossment.
Senator Hughes moves passage to engrossment. There is objection. The Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell. Cook,
22
Creighton.
ayes, 9 nays. The bill is passed to engrossment and will hold there.
Thank you, Mr. President. Thank you, members.
Senator Paxton, you're recognized for a motion to suspend the regular order of business on committee substitute for Senate Bill 1750.
Thank you, Mr. President, and thank you, members. I move to suspend the regular order of business to take up and consider Senate Bill 1750. Senate Bill 1750 replaces the $60 million cap on statewide charter schools facilities funding with an annual allotment that indexes facilities funding to student attendance growth. Removing the outdated and arbitrary cap on public charter schools facilities funding will allow charter schools to expand their capacity to meet the verified increasing demand of charter schools demonstrated by wait lists across the state without diverting resources from other priorities like teacher salaries. Senate Bill 1750 also updates the allowable uses of public charter schools facilities funding to include some of the allowable uses that traditional ISDs have available for their INS funds, such as compliance with school safety mandates and school buses. Importantly, the bill also prevents these funds from being used in a real estate transaction that would financially benefit a member of the charter's governing board, the charter holder, or charter staff. I move to suspend.
Senator Menendez, for what purpose?
Thank you, Mr. President. Questions of the author of the bill?
Senator Paxton, do you yield?
I do.
Thank you, Mr. President. Thank you, Senator Paxton. It's been very good to work with you and your team. You know, the difference between, even though charter schools are public schools, the difference between them and public community neighborhood schools is that our neighborhoods, our school districts can issue bonds. Is that correct?
That's correct.
And so that's why you're passing this bill, because they had been limited to the $60 million when we first started. Is that correct?
That's correct. And that's a lump sum that is divided among all of the charter schools. So as the number of schools has increased, the share has become less and less.
And so you and I had a conversation in committee, and your team and I, and since then we've been talking about the fact that every time a public school district wants to increase debt, they convene typically, community groups, they have conversations, and they end up having a bond election. And so in order to have transparency, public transparency, and I think you're in agreement with transparency even for these public schools too, right?
I'm in agreement with transparency pretty much everywhere.
I appreciate that, because this bill's got a pretty big fiscal note. Is it what's about over $600 million?
I believe so.
Okay, and so that $600 million is for all the...
Actually, with the committee sub, it's now down to around 200, I think.
250? Okay, 250 for all the charter schools.
Yes.
Okay. And so I want to thank you for working with me on an amendment that even though we know charter schools are subject to open meetings, but I want to make sure that when it comes to new debt, that they have a process as well to let the community know.
Absolutely, and I really appreciate the way your office has worked with mine to come to something that I think we both find very important, which is transparency, especially around finances.
Thank you very much. Thank you for answering my questions. Thank you, Mr. President.
Thank you, Senator Menendez.
Senator Paxton moves suspension of the regular order of business on committee substitute for Senate Bill 1750. There is objection. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco,
24 ayes, 7 nays. Rules are suspended. Chair lays out on second reading committee substitute for Senate Bill 1750. Secretary will read the caption.
Committee substitute Senate Bill 1750 relating to instructional facilities funding for certain open enrollment charter schools.
Following an amendment. Secretary read the amendment.
Floor amendment number 1 by West.
Senator West recognized.
Thank you very much, Mr. President. This would amend the current requirement in Senate Bill 1750 that charter schools affirm none of their employees or governing board members receive any benefit from a real estate transaction prior to receiving facilities funding. Specifically, this amendment adds individuals within the third degree of consanguinity, a second degree of infinity, to the list of prohibited individuals for the purposes of real estate transaction affidavits required in the bill. This will ensure that family members of school employees will not be able to use as a loophole to this requirement. I think this amendment is co-signed by the author of the bill, so therefore I think it's okay.
Senator Paxton recognized.
Thank you, Senator West. I think that this adjustment enhances the bill, makes it better, and the bill is acceptable to the author.
Questions on the adoption of floor amendment number 1. Is there objection? Hearing none, the amendment is adopted. Following amendment, Secretary read the amendment.
Floor amendment number 2 by Menendez.
Senator Menendez, you're recognized.
Thank you, Mr. President. I'll wait for everybody to get a copy of this very simple amendment. Mr. President, members, under current law, we all understand that it's expected, but it's not explicit that charter schools hold public meetings when deciding to take on bond debt. So what this amendment, because of the fact that Senate Bill 1750 not only increases the cap for facility funding, it also adds new types of bond debt that can be paid for through this funding. So since the charter schools are funded by public dollars, and it is our opinion that they have the same transparency as our public school districts, independent school districts. So in response to the concerns, I'm proposing this amendment, making it crystal clear that a charter school must be subject to the Open Meetings Act and receive public input before they take on this new debt from the bonds. And while I understand that charter school private bonds do not have the same taxing implications as public schools, the impact on the community with their tax dollars is still very real. And look, we can all agree, charter schools are public schools. And so I agree that as such, we should be asked of the same transparency of them that we do our independent public school districts. This amendment will ensure that the public is aware of why a bond is being issued, how the bond will be used, and the impact on the finances to the school and the community. And I believe it's acceptable to the author. Thank you, Mr. President and members.
Senator Paxton, you're recognized.
Thank you, Mr. President. Thank you, Senator Menendez, for this amendment. This is what we just discussed. And I do 100% agree that our charter schools are public schools. They are for all of our kids. And I deeply appreciate the bipartisan support on this bill, because this bill is for all kids in Texas, and it is acceptable to the author.
Questions on the adoption of floor amendment number 2. Is there objection? Hearing none, the amendment is adopted.
Thank you.
Senator Paxton, you're recognized for a motion.
Mr. President, I move passage to engrossment.
Senator Paxton moves passage to engrossment. There is objection. The Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook, Creighton, Eckhart,
26 ayes, 5 nays. Bill is passed to engrossment. Senator Paxton, you're recognized for a motion to suspend the constitutional 3-day rule.
So moved.
Senator Paxton moves suspension of the 3-day rule. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook, Creighton, Eckhart.
26 ayes, 5 nays. Rules are suspended. Chair lays out on third reading and final passage of Committee Substitute for Senate Bill 1750. The Secretary will read the caption.
Committee Substitute, Senate Bill 1750, relating to instructional facilities funding for certain open enrollment charter schools.
Chair recognizes Senator Cook to speak on the bill.
Thank you, Mr. President, and thank you, Senator Paxton. We've had a lot of really good conversations about how we both just care a bunch about Texas kids. And it is obvious that there's been a lot of bipartisan work on this bill. On behalf of my district, I do want to say a few things. And 30 years ago, Texas charter schools began as an experiment, and today we have data proving that the results really don't justify the cost. SB 1750 proposes a $665 million increase for the charter school facilities. That's on top of the $393 million that they already receive annually through small and mid-size allotment. An allotment traditional public school districts don't even qualify for once they grow past 5,000 students. Charter schools receive 17% of all state aid for public schools, but they only serve 8% of Texas children. They're basically bleeding money from our neighborhood public schools, and the results just aren't there. Since 1995, over a third of charter schools approved in Texas have closed, and charter high schools graduate less than 5% of Texas public school students, while public ISDs graduate the other 95%. Charter schools have nearly doubled the rate of DNF-rated campuses and a 6 times higher rate of failing districts compared to ISDs. Doling out more money for a system that I really see as broken with relaxed oversight is ultimately not the best thing for Texas children. Thank you all so much.
Senator Paxton, you're recognized for a motion.
Thank you, Mr. President. Thank you, Senator Cook. And one of the things that is exciting about this bill is that it is for all Texas kids. Our charter schools serve fewer people than desire to be served. As the tremendous wait lists demonstrate, parents want charter schools for their kids. And so on behalf of those families and all Texas families who will benefit from the opportunities that these charter schools will be able to offer as a result of this bill, again, with bipartisan support, I move final passage.
Senator Paxton moves final passage of Committee Substitute for Senate Bill 1750. The Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell,
26
Cook.
ayes, 5 nays. The bill is finally passed. Congratulations.
Thank you, Mr. President. Thank you, members.
Senator Hughes, you're recognized for a motion to suspend the constitutional 3-day rule.
Thank you, Mr. President. I move to suspend the constitutional rule that bills be read on 3 several days on Senate Bill 310.
Senator Hughes moves suspension of the 3-day rule. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook.
26 ayes, 6 nays. Rules are suspended. Chair lays out on third reading final passage of Senate Bill 310. Secretary, read the caption.
Senate Bill 310, relating to the determination of a majority vote in certain elections.
Senator Hughes, you're recognized for a motion.
Thank you, Mr. President. I move final passage.
Senator Hughes moves final passage of Senate Bill 310. The Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook, Creighton.
24 ayes, 7 nays. The bill is finally passed. Congratulations, Senator.
Thank you, Mr. President, and thank you, members. Thank you very much.
Senator Kokhorst, You're recognized for a motion to suspend the regular order of business on committee substitute for Senate Bill 819.
Thank you, Mr. President and members. I move to suspend the Senate's regular order of business and take up and consider at this time committee substitute to Senate Bill 819. Members, this is a bill very similar but slightly different than the version of Senate Bill 624 from last session that passed the Senate 21-9 with support from both Republicans and Democrats. Over the interim, many things have happened, and we have worked for about 26 months with sometimes no input from the wind industry, a little bit of input from the solar industry, and a whole lot of input from landowners that have worked with us and had concerns, shared concerns across districts like Senator Huffman, myself, and many of you as well. We listened to testimony during the hearing and crafted the committee substitute. Last year in my district in Fayette County, there was a proposed wind project. Literally hundreds of people showed up at a town hall meeting on a Sunday afternoon. The people questioned what they could do about 600-foot towers in probably the most gorgeous part of Fayette County and maybe one of the prettiest parts of Texas on top of the bluff of the Colorado River. When they learned that there was no approval process for these projects, they were somewhat shocked. SB 18 gives a voice to Texans about utility-scale projects. At the same time, folks in Lee County had concerns about a natural gas plant. I asked for a public meeting, and it was granted by TCEQ. When the wind and solar industry says that committee substitute to Senate Bill 819 discriminates against them, they're right. Unlike dispatchable generation, under this bill, they aren't even required to hold a public meeting. Instead, just a public notice. So Senate Bill 819 and the committee substitute is about creating a balance between preserving landowner rights in Wild Texas and the need for generation that Texas must have to keep up with load growths, much of which is driven by, of course, data centers right now. The bill is a reasonable approach to ensure the PUC is able to objectively call balls and strikes. While the original language had the PUC needing to take action for a project to interconnect, the substitute instead calls for interconnection to be granted unless the PUC takes action to prohibit it. The PUC must act to prohibit the interconnection no later than the 180th day after the date of application was submitted to the PUC. If the PUC takes no action, the interconnection is allowed. The PUC can only prohibit interconnection if the harm caused by the construction and interconnection of the facility substantially outweighs the benefit provided to the state. A majority of states have some type of siting requirements for wind and solar, including California, that is #1 in solar and #10 in wind. This legislation will not stop construction of wind and solar installations. Public notice in a county paper of record is required by public meetings. And for a complete application, a facility must include a site plan that has setbacks unless waived by the adjacent property owner. For solar installations, 200 feet from the private residence and 100 feet from the property line. And for wind installation, we took it from 3,000 feet down to 1,000 feet. And I will say also it adds financial assurance in the form of a surety bond. The substitute also adds permissive elements to application, including allowing for national security analysis, letters of support from local elected officials, environmental impact analysis, and any kind of information related to permit of notification related to the facility issued by TCEQ or Texas Parks and Wildlife. And then, of course, fire mitigation plans. It allows the PUC to assess a fee to cover the cost of reviewing the applications, and it restores, actually, the committee substitute puts back the ability for county tax abatement so a county commissioner's court can make that decision. Senator Hall will have an amendment that we have worked on for 2 or 3 days now that will be acceptable, but I am happy to walk you all through that. It's just addressing some of the concerns that he had in the bill. With that, Mr. President, I move to suspend the regular order of business or take any questions.
Senator Menendez, for what purpose?
Thank you, Mr. President. Questions of the author?
Senator Colcourse, do you yield?
I do.
Thank you, Mr. President. Thank you, Senator Colcourse. I was reading your bill, and I remember it from committee well. And I do appreciate the fact that you took the on lines 40, page 247 for a wind power facility. Ensure all facility equipment is located at least 1,000 feet from the property line. So you say all facility equipment. Typically, when we think of a wind power facility, we're thinking about the turbine, right? The pole. But if this says facility equipment, would that include maybe a transfer station, a breaker box or something? If you put that, if you say 1,000 feet from the property line, every 1,000 feet we limit, I guess we're limiting the distance or the use of the property owner who is trying to sign a lease with the wind power company. Is that not correct?
I don't think so, and I think Senator Hall is going to have an amendment that is more specific to the turbine and the height of the turbine. As you remember last session, I think it was Senator Springer put on an amendment to take it to 3,000 feet. Yeah. If you look at other states that have siting requirements, and I've studied most of them, 1,000 feet is definitely not out of line, and I don't believe that it would when you look at a substation, that's not what it's meant for. You know, I was talking to Senator King when we were laying out the bill, and, you know, some concerns that some of this is not very far from a residence, a property line. There's also consideration that, and when you talk about private property rights, if you have too many wind turbines that go right up to the fence line, you actually could prohibit the next landowner, if they were a smaller landowner, from being able to lease their land. So I think that this is in line with what I've seen other states do, and I'm pretty comfortable with it.
I appreciate that. On the solar site plan, just above that, lines 41 through 46, you say that we should have 100 feet from the property line unless the applicants obtain a written waiver. And then you go on section B to say on line 44, 200 feet from any habitable structure unless the applicant has obtained a written waiver from the owner. Does that apply in any way, shape, or form to someone's own, let's say if they have a wind farm on their property that they want to use to power their home or their barn or their own properties, do they have to be 200 feet away from their property?
No.
Okay. How do we distinguish that?
Well, again, that's a solar. That's a solar, and this only applies to 10 megawatts or more. So we're talking about large. You and I were just talking. Right. I think 10 megawatts can power 7,200 plus homes, and so that's what this bill is completely. It only applies to a facility that's going to create basically a large grade facility.
Do we apply the same types of setbacks and restrictions for pump jacks and any other energy?
We actually do. I did a lot of research on some of that. So on oil and gas, minimum distance between wells is 1,200 feet. On separate leases and units, minimum distance from lease lines is 467 feet from any property line or lease line. That's in the Texas Administrative Code. We also have statewide spacing rules.
467 feet? And so, but in your bill, you have 1,000 feet for the wind facility.
And the wind turbine is really just the concern of if one were to be sheared off, what if it fell? And that's a pretty big concern. And I think that, you know, a pump jack is not just very tall, but we're talking some wind turbines now are like 800 feet. I didn't even know they went above 600 feet. That's new to me, but that's what I've heard.
How tall the ones that are currently being used in Texas on the actual, because we know we have some in the Gulf, but I'm wondering the ones that are actually on land.
It varies. So the one in Fayette County, and you'll certainly have a good chuckle at this. So I was sitting on a back porch one night working really hard on something, and Jimmy says, "Well, what are you working on?" And I said, man, there's a wind farm proposed in Fayette County. And he goes, the wind does not blow hard enough for Fayette County to have a wind farm. I can assure you, we have grown up here all of our lives. And I go, yeah. I said, you know, that bluff, it's a switchback. Robert Nichols would laugh about that because I've worked on that switchback forever. It's very dangerous that trucks go up and down that switchback. But you go to the top of the bluff. And again, it's one of the most beautiful view corridors I've ever seen. And I said to Jimmy, they're going to put 600-foot wind turbines in Fayette County on the bluff. And he goes, that's incredible. He goes, I just don't see it working, but 600 feet, you know, is 2 football fields without the end zones. Of course, the end zones are 10 yards each. I know that, you know, I love football.
Yes.
But 2 football fields tall. So if you look at the one on the Devil's River that was proposed near the Laughlin Air Force Base, I believe those were similar at about 600 feet. But you can look at 200 feet. I was looking at one of the states that I was studying on their siting restrictions, and they actually, and I can recall it, it is one of the states said, hey, if you're 200 feet or below, you don't have any siting restrictions. But if you're above 200 feet, we're gonna make you have these siting restrictions. So they do vary, and they vary from where they're placed and the wind generation. So it's really interesting to see what Senator Menendez, and you've been on the committee, you've seen this bill twice. We sat through a lot of input in business and commerce, out of character, that we might have that many witnesses, but we had witnesses that came for the bill. We had witnesses that came against the bill. We had some really good input. And after the bill hearing, I literally went to the office, assembled my general counsel, and tried to call some other lawyers and start working through what I heard that day. And that's why I offered the committee substitute the way I did.
My last 2 questions have to do with the process of notice. And I am one for public notice. I do think it's important to have the community involved. But I notice here on, I guess it starts on line 61 of the second page, we require the applicant to, 1, provide notice of the application to the county judge of each county located within 25 miles of the boundary of the renewable energy generation facility. Do we have that same type of requirement for any other energy generation permit?
Well, actually, and this is kind of interesting, when you look at a natural gas plant, and again, I just went through this in Lee County, when you have someone, and most county judges know when there's a big plant coming in, because you do go there, most of the time they ask for tax abatements.
Right.
And so that's how the county judges are usually notified. But what struck me as so interesting was that a natural gas plant, and if you look at the footprint, and I've been at the one in Montgomery County, is the most recent. It's a cogen over there in Montgomery County. And if you look at it, the size of this floor, a little bit beyond that, people around there can request, and I did request from TCEQ, a public hearing, a public notice, public hearing, and they're granting that on a natural gas plant. You don't do that with wind turbines that are 2 football fields high, that you literally, I've seen reports that you can see from 30 miles away.
For sure.
So you ask which one does more damage to a landowner. You have lots of requirements from what were required on air permits, on some of our other natural gas plants, obviously coal. You know the requirements that we have on, because we've heard it in committee, what we have, the restrictions on nuclear, even the small modular nuclear reactors that we're looking at, not even reactors, but using the salts. So it seems that every other industry has requirements of some sort, but wind and solar.
Okay, so what about on the application process? So you're telling me this would be the first time we're going to have for any generation an application process where the commission has 6 months, up to 180 days. This is on page 3 at the very top of your bill. It says here that they cannot do it any later than the 180th day. So they have up to 6 months to get a decision.
Sure.
Do we put that type of delay in any other generation? Because I know we're in a crunch to get more power on, and I was surprised that we had a 6-month delay possibly.
Right. And I don't believe that it is a delay because it does take quite a long time to be able to, I'm looking up something for you. It does take a long time, obviously, to get these going. And so that's why I just put it at 180 days. But if you look at a drilling permit, you have to, for oil and gas, you have to apply for a drilling permit with the Railroad Commission. You have to have your injection and disposal permits. You have to have environmental permits, air quality permits from the TCEQ, wastewater discharge permits, and that's just for oil and gas. And so I don't believe that this is out of line, and it certainly is not out of line with what we're seeing in other states. For example, probably more than you want to know, but in looking at Oklahoma. So Oklahoma's pretty big in wind and solar. But you look at, they have statewide permits. Wind farms need to acquire a permit from the Oklahoma Corporation Commission. They also have an environmental impact assessment. They have bird and bat conservation. They have guidelines for protecting birds and bat populations. They have setback regulations. They even have setback regulations from roads. They have the interconnection. The Oklahoma Corporation Commission regulates the interconnection of the wind farms to the state's electrical grid. They also have safety regulations that they have to do, the decommissioning plans, community and local engagements. And so, again, I was really just trying to balance this. In my studies, Oklahoma is, they were kind of in the forefront of this before Texas. Now Texas is #1 in wind, #2 in solar, will overtake California not that long. California, very restrictive, very restrictive. And certainly I don't want Texas to be there because we want these megawatts, but we also, I think, need to be careful about sensitive areas like the Devil's River, maybe the coastline with our migratory birds, potentially, some national security issues, which is what I put in the substitute. Senator Blanco, you brought that up during the committee hearing, is the question was, do we have anything to consider national security? Because we saw what happened at Laughlin Air Force Base. Was it going to in any way interfere with, that's, where we train a lot of our pilots. Was that going to? Does it interfere with the radars? And so I think that the way we're approaching this is in a good way and in line with other states. We certainly won't be the most onerous. In fact, I would put us in still the category of having some of the least restrictions. And let me say finally, Senator Menendez, you and I were freshmen over there in 2001, and then we were freshmen over here in 2015. And one of the things is that not only myself, but my staff, we will work with anyone. And we have asked and asked and asked and asked and asked the wind and solar folks to come in and work with us and tell us, what would you redline? What would you be able to live with? Over and over. And they choose not to talk. They choose not to talk. And so I really was negotiating against myself. And in that negotiation against myself, I landed where I thought was the balance between preserving Texas in a conservation way, that there should be some off limits. We're not going to cover up every inch of Texas with a solar panel. Maybe we should give some consideration in East Texas, where we've clear cut 7,000 acres of our hardwood forest. They're gone. Maybe we shouldn't be next to the Neches River, which is a wild river, one of the few left, certainly in our state and in the United States. Maybe those, because as you clean a solar panel, you spray chemicals on it. That's how you clean it. And I will say that panels get really dirty. You might be surprised to know that I have a solar panel. I have a solar well. And one day it wasn't pumping very hard, and we don't use it very often. I'm not a prepper, but maybe I am a prepper, just in case. If everything goes off the grid, I'm going to have water, and I tell all my friends and my family, get to our house, we're going to have water with our solar well. I'm not against solar, but I learned that one day it wasn't pumping very hard, and Jimmy goes, oh man, I think we've got a problem. And we called the well driller, and he says, no, you got to clean those panels. Well, of course, we just got out there with brush and water and cleaned it off. But if you talk to the industry, obviously they use chemicals. Maybe those chemicals shouldn't wash into some of our rivers. Maybe there should be some setbacks. And I think that the PUC, through what they've done in their ability to do different facilities, certainly our power lines, you just gotta every once in a while say, that's a ball, balls and strikes.
So Senator, I there's a lot of what you've said, and you covered a lot of ground where we're in agreement. Where what I've heard you say is we need to protect our state, protect the environment. I heard you talk about not wanting to see chemicals in our water streams and all of the things that we're in agreement. But you also have to, and I do appreciate the fact that you've talked about balance, the balance between wanting to do the right thing for the environment, but also respecting people's personal property rights. Whoever had those 7,000 acres in East Texas, nobody forced them to clear cut those. They signed an agreement and they made a deal. So my only concern is that, and possibly, and it seems like your bill's not going to get there, but I am worried that in our zeal to potentially protect against something that some of us on this floor don't feel like we need any more of right now, that we need more dispatchable energy, that in that zeal that we keep people who maybe that solar lease or that wind lease is the only thing that may help them get out of a financial bind. And that's a concern that I have, that we are going to interfere with people's personal property rights. And you and I are both supporters of personal property rights. We believe in this, in capitalism. We believe in the right to do what you want with your own land and not have government interfere with that. And that's where there is a balance, because I do agree with you. We have to protect. I believe in zoning rights. I believe in using the land. So I appreciate you taking my questions.
I do too. And when you talked about zoning, of course, if you live in a city limit, you kind of have the protections of that. But if you don't, then, it's that balance of where does your property rights end and mine begin. And again, this bill is not meant to stop wind and solar. Okay. Much to the chagrin of what you might hear out there, it is not. I believe that we need the megawatts, but I also believe there's a balance that I don't want to see every inch of Texas covered up as well.
Agree.
And there are potentially bat populations that we need to protect. Senator Eckhart had a bill in water, agriculture, and rural affairs. I couldn't have agreed with her more. And so as we look to balance this, we are number one in wind. We are number two in solar, and we will be number one in solar very soon. And this bill will not stop that.
Does it impact battery storage at all?
Pardon me?
Battery storage facilities.
Does not include battery storage, and quite honestly, I've had a lot of questions on that. Senator Schwartner, Chair Schwartner, is working on some battery issues, and you were in the presentation where we had, and this is really revealing, and do you remember this? When we looked at this, I remember Senator Nichols leaning over to me. He could not believe the lines that we saw. The brighter red is solar. The darker red is battery. Wow.
Yeah.
Wow, that's a big issue. So hopefully with batteries, I'm receiving a lot of complaints in my district about the battery, I call them farms, BESS, B-E-S-S, that are popping up everywhere. We're going to have to strike a balance there, especially with the fire hazards, and should they go right next to schools?
Yeah, for sure.
It's a question.
Thank you for answering my questions. Thank you, Mr. President, members.
Senator Kokors moves suspension of the regular order of business on committee substitute for Senate Bill 819. There is objection. Secretary will call the roll.
Alvarado, Bencourt, Birdwell, Blanco, Campbell.
22 ayes, 9 nays. Rules are suspended. Chair lays out on second reading. Committee substitute for Senate Bill 819. The Secretary will read the caption.
Committee substitute Senate Bill 819 relating to renewable energy generation facilities.
Following amendment. Secretary will read the amendment.
Floor Amendment number 1 by Colcourse.
Senator Colcourse, you're recognized.
Thank you. Members, after the Business and Commerce Committee hearing on Senate Bill 819, I visited with several senators regarding a public record of decisions on projects. I want to thank Senator King for suggesting that we require the PUC to post decisions on their website. Since the process in SB 819 does not require a public hearing by the PUC, the posting of decisions will keep Texans informed, and this will ensure that the public is informed and the process is transparent. So thank you, Senator King, for your suggestion, and it's acceptable to the author.
Questions on the adoption floor amendment number 1. Is there objection? Hearing none. Amendment is adopted. Following amendment, Secretary read the amendment.
Floor Amendment number 2 by Hall.
Senator Hall, you're recognized.
Thank you, Mr. Chairman. Thank you, Senator Colcourse. Really like your bill. It's badly needed with what we are seeing in East Texas in particular, with the growing number of solar panels and wind farms out there that have no oversight, no control. They disappear. And as we experienced out there, one of the manufacturers came to one of our judges and said, we know you can't do anything about what we're doing, and you can't stop us, but we'd like to have a letter from you telling us that. And so they know what they're doing and what the situation is, and it's time that we had a bill like this, and I really like your bill, but just a few changes to it to tighten it up, because this will be a much better bill with this amendment and I offer today, in light of what is happening all across our rural area. Our rural areas are not equipped for the uncontrolled influx of renewable energy sources, and they are uncontrolled. And I recognize these projects would add capacity to our energy resources, but at what cost, and ultimately, what impact to dispatchable energy we would have. My amendment would help make sure our rural areas are better equipped with the necessary processes, knowledges, and resources to handle this. The amendment has been vetted, and I appreciate you accepting this. It does 4 things. It specifically would move section C, numbers 1, 2, and 4, to a mandatory section rather than a may section to make sure it happens. And it document and support opposition from the governing body of the subdivision in the area where the renewable energy generation facility is planned. And we need documentation demonstrating that the project will not have any negative impact on national security would also be required under this amendment. And information related to the permit of other state authorization issued by TCEQ and Parks and Wildlife was also be included in the application under this amendment. And the next part strikes the above move sections from C and renumbers accordingly. And then this amendment will also change the setback for wind facilities from 1,000 feet to simply twice the height of a turbine, including the blade. And lastly, this amendment changes may to shall on page 3 in line 30 to ensure the commission adopts and enforces rules on this bill.
Senator Menendez, for what purpose?
Questions of the author of the amendment, Mr. President?
Senator Hall, do you yield?
Yes. Yes.
Thank you, Mr. President. Thank you, Senator Hall. Senator Hall, I was just curious, on the twice the height of the wind turbine, so let's say the wind turbine we've been discussing, some are 2, some are 4, some are 600. So would it be twice the size of the pole? Because then you go on to say including the blades.
Including the blade, yes.
What does that mean? Do I add all 3 blades?
You add the length of the blade to the height of the pole.
All 3 of them or one of them?
Just one.
Including, because it says blades. Yeah. So that's interesting. How did you come to that conclusion that that?
Well, because blades are known to fail, and they're moving at a pretty good speed. And the best estimate was at about the distance they could throw that blade off of the property would be what we came up with, the height of twice the height of the pole to protect the adjacent landowner.
Do we have any documentation or history of any of these blades falling off any of these turbines? Is there anything?
Oh, absolutely. We got a whole acres and acres of blades out in West Texas being stored that have either worn out or broken.
But have any of these blades been as you've mentioned, thrown off the turbine while it was operating?
I've not witnessed any of them.
I hadn't either. That's why I was asking.
I've had the concern has been there, and with the blades being, we know they will throw them off.
Okay. On the documentation that you asked for in the first part of your amendment, where you ask it won't have a negative effect on national security, the Texas Commission on Environmental Quality or Parks and Rec will also, I guess, information related to the permit. Is this, all of these requirements also within the 180 days, or is this in addition to the 180?
No, it's all within 180 days.
Okay. Thank you for answering my question.
Thank you, sir.
Senator Colcourse.
Yes, thank you for your questions, Senator Menendez. If you look at what his does is, it really doesn't change much in the bill, a little bit on the height. It actually might lessen the 1,000 feet if it's a smaller facility, depending on the height of the blade. But it basically, I call it, moves 3 elements above the line that were permissive before, and all of these require that the elements be required. It requires the applicant to include support or opposition. He adds opposition, which I think is good, from locally elected leaders. The applicant must provide information on permits, TCEQ or TPNW, and then finally it does an analysis of the project negative impact on national security. So we just move that above the line, and then the rest below stays permissive, and so it is acceptable. And making the PUC adopt rules, it is my understanding, and working with the PUC, they were going to do that anyway. So the amendment is acceptable to the author.
The question is on the adoption of floor amendment number 2. Is there objection? Hearing none, the amendment is adopted. Senator Colcourse, you're recognized for a motion.
Thank you, Mr. President. I move that committee substitute to Senate Bill 819 pass to engrossment.
Senator Colcourse moves passage to engrossment. There is objection. The Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell, Cook, Creighton.
22 ayes, 9 nays. Bill is passed to engrossment and will hold there.
Thank you, Mr. President. Thank you, members.
So who was the first? You have, who did she say? Menendez, Zaffarini. So which one are we doing?
Senator Bettencourt, you're recognized for a motion to suspend the regular order of business on Senate Bill.
Thank you, Mr. President.
Suspend the 3-day rule.
So moved, Mr. President.
Senator Bettencourt moves suspension of the 3-day rule. Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell, Cook, Creighton,
25 ayes, 6 nays. Rules are suspended. Chair lays out on 3rd reading and final passage Senate Bill 1541. Secretary, read the caption.
Senate Bill 1541 relating to state oversight of county elections following a county election audit.
Senator Bettencourt, you're recognized for a motion.
Thank you, Mr. President. I move final passage of Senate Bill 1541.
Senator Bettencourt moves final passage of Senate Bill 1541. The Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell.
25 ayes, 6 nays. Bill is finally passed. Congratulations, Senator.
Thank you, Mr. President and members.
Senator Colcourse, you're recognized for a motion to suspend the constitutional 3-day rule.
Thank you, Mr. President. So moved.
Senator Colcourse moves suspension of the three-day rule. Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell, Cook.
25 ayes, 6 nays. The rules are suspended. Chair lays out on third reading and final passage of committee substitute for Senate Bill 819. Secretary read the caption.
Committee substitute Senate Bill 819 relating to renewable energy generation facilities.
Senator Colcourse, you're recognized for a motion.
Thank you, Mr. President and members. I move final passage of committee substitute to Senate Bill 819.
Senator Colcourse moves final passage of committee substitute for Senate Bill 819. Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell, Cook.
22 ayes, 9 nays. Bill is finally passed.
Thank you, Mr. President. Thank you, members.
Senator Hancock. You're recognized for a motion to suspend the regular order of business on committee substitute for Senate Bill 1233.
Thank you, Mr. President. I move to suspend the regular order of business, take and consider a committee substitute Senate Bill 1233 at this time. Members, committee substitute Senate Bill 1233 will ensure that pregnant women receive all information regarding perinatal palliative care upon the diagnosis of her unborn child's life-threatening or life-limiting illness or medical condition. As outlined in the bill, perinatal palliative care includes providing comprehensive supportive care to reduce the suffering of a pregnant woman, her unborn child, and her family, from the time the unborn child is diagnosed until 1 year after birth. Currently, many pregnant women receive their diagnosis or are unaware of the services available to ease the pain and suffering that they may endure. We want to make sure that expectant mothers are providing the information they need to best navigate caring for their child before and after they are born. With that, Mr. President, I do have an amendment.
Senator Hancock moves suspension of the regular order of business on committee substitute for Senate Bill 1233. There is objection. The Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell,
24
Cook.
ayes, 7 nays. Rules are suspended. Chair lays out on second reading committee substitute for Senate Bill 1233. The Secretary will read the caption.
Committee substitute Senate Bill 1233 relating to information regarding perinatal palliative care.
Following an amendment, Secretary read the amendment.
Floor amendment number 1 by Hancock.
Senator Hancock, you're recognized.
Yes, thank you, Mr. President. This simply addresses a timeline error that stated in the bill on page 2, line 8, before conception, and changes that to an at conception.
The question is, Senator Menendez, for what purpose?
Quick question of the author, Mr. President.
Senator Hancock, do you yield?
I yield for a question.
Thank you, Senator Hancock. My understanding is that this perinatal palliative care is available, correct? Is already available?
Are we on the amendment?
No, not on the amendment.
Okay. Yeah, this just provides additional notification and information providing to those once they're diagnosed.
And I think your bill, I think it has a penalty. Is it a $1,000 penalty? It says on page 3, line 6, for each subsequent violation to impose a provider an administrative penalty in the amount of $1,000.
Now, for those that are failing to provide the information.
Okay, and then you give a written warning. All right, thank you. Thank you. I just checking on. Thank you, Mr. President.
Question is on the adoption of floor amendment number 1. Is there objection? Hearing none, the amendment is adopted. Senator Hancock, you recognized for a motion.
Yes, thank you, Mr. President. I move passage to engrossment.
Senator Hancock moves passage to engrossment. There is objection. The Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell, Cook, Creighton.
24 ayes, 7 nays. We'll hold there, Senator. Find a friend.
Oh.
Senator Hancock, you're recognized for a motion to suspend the constitutional 3-day rule.
So moved, Mr. President.
Senator Hancock moves suspension of the 3-day rule. Secretary will call the roll.
Alvarado, Bencourt, Bardwell, Blanco, Campbell.
25 ayes, 6 nays. Rules are suspended. Chair lays out on third reading and final passage of Committee Substitute for Senate Bill 1233. Secretary, read the caption.
Committee Substitute Senate Bill 1233 relating to information regarding perinatal palliative care.
Senator Hancock, you're recognized for a motion.
Yes, I move final passage of Committee Substitute Senate Bill 1233.
Senator Hancock moves final passage of Committee Substitute for Senate Bill 1233. The Secretary will call the roll.
Alvarado, Bettencourt, Bardwell, Blanco, Campbell.
24 ayes, 7 nays. Bill is finally passed. Congratulations, Senator.
Thank you.
Senator Nichols, you're recognized for a motion to suspend the regular order of business on Committee Substitute for Senate Bill 1405.
Thank you. Thank you, Mr. President. I move to suspend the regular order of business on Committee Substitute for Senate Bill 1405. Members, this continues our work to expand the broadband access in Texas by streamlining the process at the Texas Broadband Office and aligning Texas statute with federal rules. The bill does several different things. It amends the definition of broadband service to match FCC standards. It updates the definition of underserved to match FCC standards. It streamlines the processes at the BDO for only requiring a comptroller to submit a report on the pole replacement program if there was fund activity the previous year. It eliminates the annual mapping update to adopt the federal communication maps, streamlines the process of awarding grants, loans to the program, ensures that internet access is not a taxable service. It also ensures that state-funded grants for broadband programs are tax exempt. And with that, I move that we suspend the regular order of business on Committee Substitute Senate Bill 1405.
Senator Nichols moves suspension of the regular order of business on Committee Substitute for Senate Bill 1405. There is objection. The Secretary will call the roll.
Alvarado, Bettencourt, Bardwell, Blanco, Campbell.
28 ayes, 3 nays. Rules are suspended. Chair lays out on second reading Committee Substitute Senate Bill 1405. Secretary, read the caption.
Committee Substitute Senate Bill 1405 relating to increasing access to and reducing taxation of internet services.
Following amendment, Secretary, read the amendment.
Floor Amendment Number 1 by Nichols.
Senator Nichols, you're recognized.
Thank you. Members, I do have the floor amendment as private property rights protections to the programs within the Broadband Development Office. It would require the Broadband Office to take in consideration whether an applicant has repeatedly violated private property rights or caused property damage. Affected property owners could submit affidavits to the office showing the conduct. The amendment also subjects awards withdrawal if the recipient is found repeatedly violating private property rights or damaged private property. The amendment gives BDO the authority to make rules for this process, including an opportunity for award recipients subject to a potential withdrawal to respond for the action. It's fairly simple to read. With that, I move we adopt the floor amendment number 1.
Questions on the adoption of floor amendment number 1. Is there objection? Hearing none, the amendment is adopted. Senator Nichols, you're recognized for a motion.
I move passage to engrossment of the committee substitute for Senate Bill 1405.
Senator Nichols moves passage to engrossment. There is objection. The secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell.
28 ayes, 3 nays. Bill is passed to engrossment. Senator Nichols, you're recognized for a motion to suspend the constitutional 3-day rule.
I move we suspend the 3-day rule.
Senator Nichols moves suspension of the 3-day rule. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell.
28 ayes, 3 nays. Rules are suspended. Chair lays out on third reading and final passage committee substitute Senate Bill 1405. Secretary, read the caption.
Committee substitute Senate Bill 1405 relating to increasing access to and reducing taxation of internet services.
Senator Nichols recognized for a motion.
I move final passage of committee substitute Senate Bill 1405.
Senator Nichols moves final passage of committee substitute for Senate Bill 1405. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell.
28 ayes, 3 nays. Bill is finally passed. Congratulations.
Thank you, Mr. President and members.
Senator Creighton, you're recognized for a motion to suspend the regular order of business on committee substitute for Senate Bill 37.
Thank you, Mr. President. Members, committee substitute for Senate Bill 37 seeks to bolster governing board authority, reform faculty senates, and clean up a patchwork of general education requirements across our post-secondary institutions. It also increases transparency and compliance efforts at our public institutions of higher education through the creation of a statewide higher education ombudsman's office. Thank you, Mr. President. Members, I move suspension of the regular order of business to take up and consider committee substitute for Senate Bill 37.
Senator Miles, for what purpose?
Questions to the author, Mr.
Senator
President.
Creighton, do you yield?
Yes, of course, I'll yield.
Senator Creighton, with Senate Bill 37, are you not concerned that this bill would alter the balance of power between faculty and governing boards in higher education?
I'm not concerned with that, Senator Miles. I feel that it will clarify that faculty senate has a role that's advisory in nature, and that the administration for the university and the regents make the final decision making.
So, like you said, you really see this as a cleanup bill? You really see this as a cleanup bill? You said that in your statement.
Yes, I see it as a clarification in statute what the roles are on our campuses across the state for leadership, for advisory opinions only and recommendations, and for final authority.
So you believe that political appointees on governing boards should have this much leverage or control over academic leaders?
I do. I think ultimately the responsibility lies with the chancellor, with the president, and certainly in charge of the administration on each campus, and with the boards of regents.
So you have no feelings that this may place some undue pressure on institutions to police political or ideological viewpoints among faculty and administrations? You're not concerned about that at all?
I'm not, and in fact, the Faculty Senate, as a current authority and the authority for the Faculty Senate after this bill is passed would be to continue to be able to advise the university administration on any concerns about exactly that.
And you're not worried about this legislation targeting what is being taught at our universities, that there are faculty members who are leaving our state because they are not being able to do or being punished for their research. And this will continue to occur, and the students are ones who will suffer the most in this situation. You're not concerned about that at all, bro?
I'm not, Senator Miles. I've not seen, any significant data talking about faculty leaving the state. I've certainly heard quite a bit about faculty coming into Texas, with the desire to apply and work for our Texas universities. And, I know we'll always continue to monitor that through the Senate Education Committee, but at this time, I'm not concerned about any data signifying that.
Well, I thought we proved last session during your critical race theory bills that our faculties were running out, and I think I showed you the data on that because they couldn't properly pursue their research.
Well, it's important that they certainly can pursue their research endeavors. We'll continue to prop up and support those goals. We've certainly done that with our supports for our Tier 1 universities and expanding off of that in recent years. So we'll continue to have that same intent.
Okay. So you're not concerned for the long-term effects of the bill approaching the governance of the curriculum that will affect students and academic experiences?
I'm not at all. I think it's the time at this day and time moving forward to make sure we understand what our core curriculum and general education curriculum makeup should be. I think there will be a recommendation process established in this legislation so that those recommendations are headed straight towards those making final decisions for our universities and our university systems. And we'll be in a better place for those recommendations not only to be established and provided, but the legislature can have final oversight each and every session if we see that they're on a different track than what we intend for them to be.
Well, I'm concerned that we're not preparing our next generation for a better society and to continue the work of healing our deep racial wounds that we've talked about on this Senate floor this session many a times, when this bill could prohibit and discourse the college classrooms around this topic. So I'm concerned about it, but obviously after I've asked you 4 times, you're not. But Senator, have you put any thought into the outcome that institutions could face from lawsuits, from faculty terminating under politically motivated performance reviews? Maybe that's a different aspect you should think of. Have you thought about that one?
I've heard about litigation requiring those applying to be a professor to sign a leftist political loyalty oath in order to get an interview. And so, yes, there's always litigation that is brought up with regard to hiring and the day-to-day experience of faculty and those that work on our campuses. But I don't believe this bill would trigger anything related to such.
Senator, we have a difference of agreement, so let me ask you, are you familiar with the Palm Beach Christian University case that the United States and the school terminated an English professor who was part of his class taught a unit on black experience. This included the works of W.E.B. Du Bois and Booker T. Washington, and discussed the racial disparities in incarceration and in education. Are you familiar with that case at all?
I'm not familiar with that case. I'm familiar with Texas cases.
Okay, which Texas case are you familiar with?
Well, there was a case out of Lubbock where a professor was terminated simply for pledging to treat every student equally, but not pledging to support DEI.
Okay. Well, I think this goes back to some conversation we had some time ago, like I said, on critical race theory. Can a professor still present information about topics on race, gender, religion, ethnicity without being a violation or of the provision outlined in this bill?
There will be recommendations from this legislation and certain committees that will recommend what is and is not appropriate to be within the general education curriculum, and then we will see from those recommendations what ties directly to a degree of value in the future with a certain return on investment placed on the degree plans that are offered, and we'll also see whether or not the total number of semester credit hours to achieve those degrees will be lessened. If they're reduced, for instance, from 42 hours down to a certain number of hours in the 30s, then I think we'll see us getting back to specific core curriculum, general education curriculum that ties directly to what will or will not produce a degree of value. So our students getting out with debt and with student loans, that with big concerns on those student loans and that debt, that they'll have more of an opportunity to get a job and be employed with wages and a salary that will take care of that exact debt.
Senator Creighton, nobody can tap dance around my questions better than you, sir. The question was, can a professor still present information about topics on race, gender, religion, and ethnicity without being in violation of provision of this bill? That was the question. Yes or no?
My answer was the review committees established in the bill will make those recommendations on what courses should or should not be offered to our administrators and our regents, and they'll make a determination on what those courses are and how they're tied directly to a degree of value.
So I'm going to take that as a no. As a yes, they still can be in violation under this bill for discussing race, gender, religion, or ethnicity. So let's move on. The bill claims to protect students from being taught to adopt an ideology, correct? The bill claims to protect students from being taught to adopt an ideology. That's what it claims in the bill. You agree?
That's correct.
That's what it claims in the bill. You agree?
Taught to adopt an ideology,
Yeah.
That's correct. They can be taught about different ideologies,
Okay.
but they can't be taught to adopt an ideology.
We're saying the same thing, I think, sir. So, but don't you think that all academic disciplines involving frameworks or theories, and how do you draw a line between theory and indoctrination? How do you draw that line?
I think what we're talking about here within this legislation is our core curriculum. What is important to include to get a degree of value? What's important to include as coursework in a general education curriculum? And this bill sets out to establish that. So part of the criteria of that, to answer your question, is no ideologies in that core curriculum would be required to be imposed.
Well, Senator, I'm concerned. I'm going to ask you last time. Are you concerned that this law could lead to self-censorship by professors fearful of professional retaliation or engaging with race or equity topics? Are you fearful of that?
I think before this bill and after this bill, we'll continue to treat every student equally, and we will continue to foster.
Are you fearful of
a campus
the concerns of self-censorship or fearful of professional retaliation?
I'm not.
For professors that engage in race or equity topics, are you fearful of that?
Only if they're outside the scope of their instructed duties within this core curriculum that's established.
Okay. Well, Senator Creighton, I want to thank you, but I am fearful of that, just like I was on last session with critical race theory. I think all of our colleagues here should be concerned about it as well. Okay? Education, our universities are places for education, is for young folks to broaden their minds and experiences. Thank you, Mr. Chairman.
Thank you, Senator Miles.
Senator Gutierrez, for what purpose?
It's just the light bulb's not working, but the microphone does. Thank you. For a few questions, Mr. President.
Senator Creighton, do you yield?
I yield.
Thank you, Senator Creighton. I do have a series of questions. I'll be brief, but I'll be thoughtful with them. It's an important subject. How many classes that teach identity politics can a university have before its degree program is deemed non-compliant?
It's not based on a certain number.
So how do you get to the situation in your bill where I think you have universities, I think the kind of the 4 performance ratings are reward, monitor, sanction, or sunset, correct? Is that the rate?
That's correct, and it's based on the committee that could be established to assist with what is and is not appropriate to be in a general education curriculum review. So that would be...
So if there's one course on identity politics, are they going to be sanctioned or slapped on the wrist? Do we know?
That's correct. I think there's different levels of those sanctions that are established in the bill itself, as I think you read some of them off.
Yeah, the sanction levels are reward, monitor, sanction, or sunset.
That's right. And so whether it's monitor and there is a notice to the university in a cure period, a certain number of days where they have to remove that particular non-compliance, that might be an example where they would go back into the reward status. What we're establishing with these committees, Senator Gutierrez, is the ability for a student to understand, are they in a degree plan and on a track for a return on investment, a debt analysis that's tied to what they'll spend, what they'll borrow, what they'll owe, and ultimately, is that degree of value something that will lead them to the workforce to make or earn a living that is sufficient enough to pay that debt off? And so any of these other courses that might fall outside of that core curriculum, that general education curriculum, would not be included.
So the course that I took in college called Latino Politics, which I could tell you had a lot of what you would call identity politics, that course would not meet your criteria in the space because it would not be beneficial to my career in the future.
Well, it would depend on the recommendations of the review committee for the curriculum reform itself. And then also the coordinating board establishes its own curriculum committee to redefine any foundational component areas and make recommendations about how those semester credit hours fit into a core curriculum. That framework established by the coordinating board would be back to what I mentioned before. It would compare a debt analysis on a degree of value and allow us to get these course credit hours required from the 40s down into the 30s. So these degrees would be more affordable, and they'd also, it'd be clear to the student what they're borrowing and what it costs to obtain that degree, and then there would be information provided on where does that degree lead that student? Does it lead them into the workforce with opportunities, or does it not?
Maybe the kid just wants to take a class to learn something about identity politics.
That would not be part of the general core curriculum to get a degree. I think that there could be opportunities outside that core curriculum set. It wouldn't be tied necessarily towards obtaining a degree, but just to learn and just to have opportunities to be exposed to other information and other coursework. I'm not saying that that wouldn't be possible.
Oh, so universities can still have those courses, they're just not going to be under this protocol, if you will.
Well, yes, and our universities now have credit and non-credit hours that they offer.
But yet, if they have these courses that meet certain factors, they're still going to get monitored or sanctioned or sunsetted. And that's my concern. My next question is this. So one of the factors that the board is reviewing is that the courses in the curriculum do not distort historical events. That's on line 55 and 56 of page 1, correct?
I can refer to that if you'd like me to, yes.
Yes, sir. We got lots of time.
Give me the page and line again.
Page 1, line 55 and 56.
I only see on page 1, 24 lines.
I'm sorry, I have this version here. It says page 1, line 55, subsection 5. It says, they do not distort significant historical events or include a curriculum that. And then it goes on to give you some subsections.
Yes, again, I think that's consistent with what the review committees would suggest as to not include in a core curriculum set.
Line 57 says another factor is a course that is teaching identity politics. We've already gone through that one. The next factor is that it is reviewed whether or not a course teaches that there was or systemic racism or misogyny in parts of the governmental systems. And that's on page, what I have is page 2, lines 2 to 5. Is that another factor?
Correct. I think just before that were the elements of critical race theory, and then this is, are you on C at the time?
Yes, sir.
Yeah.
Who makes these decisions, and who's in charge of this review? The bill mentions governing board. Is governing board the Board of Regents? Is that what we're talking about?
It would be the Board of Regents, but they can also, to clarify, they can establish a committee for assistance and advisory role.
So for us here in Austin, if it was for UT, it would be the Board of Regents, and that sounds like what you're telling us. Or somebody, some commission that they authorize.
That's correct.
Okay. Does anyone on the UT Systems Board of Regents have an academic background in history or racial history?
I'm not aware, but they would certainly be able to have an advisory committee to help them if they were not.
And is it true that under SB 33 that this governing board in our hypo here with UT, the Board of Regents, can overturn any decision made by the administration of a university?
That's correct.
In other words, so the board doesn't like the English teacher that was hired to teach, whatever, they can overturn that decision, correct?
Absolutely. They would be the buck stops there with, any situation where the university administration was not taking action, but that it was determined that the university brand was being harmed.
If they don't like how a person is disciplined, whether they were disciplined or should have been disciplined, they can overturn those decisions or lack thereof, correct?
They would have the ability to overturn definite decisions by the administration for hiring.
If the administration decides to go down a line of a certain kind of research that helps the state, if the administration decides to go down a path of some research that helps the state of Texas, they can overturn that as well, if they don't like the research that's being done.
That provision's mainly tied to hiring. If they want to reverse a decision that's made by administration on going a different route in choosing future leadership.
So let's talk about accountability, because this is important. One of the first sections, one of the first factors is about historical distortions, and you and I just talked about that. What if the governing board decided a course of action based on a professor or a class distorted the historical record? What if the board is wrong? What if the class or the instructor did not distort the record? How does that get fixed?
Well, I think that they'll have, with these committees that are established, Senator Gutierrez, they'll have well-rounded and properly vetted advice on how to make a decision. Now, you're hypothetical that they could make the wrong decision. At the end of the day, with that advice and counsel is always a possibility. And, and the governor would have to hold them accountable for that. They answer directly to the governor because they're an appointed network. The public would also, chime in on the same, because for our flagships and all of our public universities around the state and the constant coverage that the media affords to the decisions that are made on these campuses, they would be held accountable by the public as well. And then ultimately, when they're held accountable by the public, that ends up right here on this Senate floor with us making changes to deal with those decisions, good or bad.
I'm not going to get into the politics of the governor and his appointees one way or another, because I think it distorts what I'm trying to get to the truth here on the facts. And what I'm asking is that the bill has no mechanism in place to fix if a board is wrong on historical decisions. And I think you just answered that. So a lot of this plays on history, and history has an important role. Would it be a distortion to you, Senator Creighton, to teach that Texas Rangers killed dozens of Mexican Americans along the border from 1910 to 1920? Would that be a distortion?
It's clear in the bill they could not distort facts based on historical reference. So
the truth is that this period was called La Matanza, and Texas Rangers killed between 300 and 5,000 migrants. And that's the truth according to T.R. Fehrenbach on factual records. That's the truth.
I think it was important to me as the author to include in this bill a provision that protects the proper and accurate teaching of our history. That's why I added that provision. So not only is it not included, it was important enough to me as the author to make sure it was included.
I'm glad that you included that.
The good, the bad, and the ugly.
But there's no protection against when these boards and these governing bodies get it wrong. Is it a distortion that after the Civil War that 20% of Texas was African American?
The protections on any inaccuracies, Senator Gutierrez, the protection would be you and I and the rest of the members on this floor as we continue to make corrections and hold our universities accountable with bills like these. We would be back once again making any adjustments we need to make. The Senate Education Committee is oversight over our public university campuses, and that's what we do in that committee.
Well, Senator Miles said earlier that you're really good, and you are an incredible lawyer. I'll give you that, because you didn't fall into that trap. It wasn't 20% African American, it was 33% African American in this state. But my concern is there's nothing in the bill to protect against a body that says this is what history is, or that class over there, that history class, is telling them that there was only dozens of Hispanics killed by Texas Rangers in 2010, when it was thousands. And so my point is, there's nothing in this bill, there's no accountability in this bill one way or another, other than you telling the public, hey, if you've got a concern that the committee, that the Board of Regents got it wrong when they fire teacher so-and-so, when they shut down this class, if you got it wrong, then you could just go complain to the governor's office.
Oh, and to you and I. I mean,
oh, yeah, for sure.
We'll have plenty of sunshine on the decisions that are made, the curriculum that's offered, what our students are learning and if it ties to a degree of value. And I'm committed to working with you and Senator Miles and everyone on this floor to make sure we hold them accountable for accuracy.
Okay, I like that. I like sunshine. It's why we have sunset bills, which I think someone tried to change in some new thing this session. Who knows? We're always naming things different things. So would you be okay with an amendment that set up a body of equal Democrats and equal Republicans every session to look at the decisions that were made by these boards of regents in the previous 2 years, so that we can come back here and determine for ourselves that they were right or they were wrong? Would you be open to that kind of amendment so we can have sunshine, so we can check on governmental appointees that are not elected by anyone other than Greg Abbott?
Well, we have a bipartisan floor, and we have a bipartisan education committee. We are moving Republican and Democrat bills every week out of that education committee, and I'm committed to continuing to work with everyone on this floor to hold our universities accountable.
I appreciate that, but you didn't answer my question. My question is, would you be amenable to an amendment that says that we will have a committee to check on the committees?
I would not, because our education committee is already in place for that purpose, and it's bipartisan.
Well, I love you like a brother. You and I go way back.
Back at you.
But we're getting old, and the distance between us is long and at least 40 feet. You missed the eye roll when I heard bipartisan.
Who's getting old?
Fair enough. Fair enough. So I'm going to take that as your answer, that you're not open to such an amendment.
Thank you, Senator Gutierrez, for offering and bringing forward the suggestion.
But I'm not done. There is more. And we have a great amendment that you're going to love, Senator Creighton. Senator Creighton, whenever you're ready.
Thank you. Yes, go ahead.
We've talked about some different historical distortions and so on. Some of my own that you haven't fallen prey to. Is it fair to say that SB 37 could be the basis for defunding an institution?
Your question is, does Senate Bill 37 allow or create a possibility where institutions could lose funding?
Yes.
Not as long as they're in compliance and work to stay in compliance. And there's a cure period in the bill if they somehow fall out of compliance, in a trap for the unwary, that they can correct those non-compliant related situations and never miss a beat on funding.
So if they don't get the shining star, which is reward, and I have an amendment that we're going to talk about for reward in a second, if they don't get that shining star, then they get monitored under your bill. Who does the monitoring?
Well, that would be a report that goes to the regents, and it would also come to us.
Then they get sanctioned, and then they get sunsetted.
That's right. There has to be enforcement in our bills. All of our bills on this floor that we pass, if we choose not to add enforcement, then we are in many ways wasting our time.
Is it fair to say that SB 37 is also the basis for rewarding compliant institutions with possible grants?
The grant process and our separate effort through the budget to provide grants and funding, both state and I'm assuming federal, will continue, is not changed by this bill.
Well, I'm very happy at least that you are so concerned with student debt, as am I. As am I. Student loans and student debt.
I maxed out as much student debt as I possibly could and then continued to borrow even beyond that, Senator Gutierrez. So it's very important to me.
As did I. So I've got a great amendment that I look forward to talking about.
Thank you, Senator Gutierrez.
Thank you, Mr. President.
Senator Menendez, what purpose?
Thank you, Mr. President. Questions of the author, Mr. President.
Do you yield, Senator?
I yield, absolutely.
Thank you, Senator Creighton. Yeah, it's quite the bill here, sort of a restructuring. Several sections. And I think some of I'm not going to ask the same questions, but I think here on page 6 of the committee substitute, starting on line 53, is sort of what goes to what Senator Gutierrez was referring to. It says, on receipt of a report under subsection K, the Attorney General may ensure the institution of higher education's compliance by acting to impose penalties on the institution, including 1, filing a civil suit against the institution to compel the institution's compliance, or to collect a civil penalty not to exceed $1,000. And then number 2, recommending to the legislature that the institution's appropriations be withheld. I guess in your bill, you have provided for a recommendation from the Attorney General to both sue, collect a civil penalty, or recommend institutions' its appropriations being withheld. Is that not correct?
That's correct. That's consistent with legislation we passed last session in Senate Bill 17, and we tried to stay close to that language. But Senator Menendez, I know, and it may help with your concerns. It may not quite get there, but in provision K, section K of that same page on line 45. The university system itself, if they made a mistake in some way, they have a month, 30 days to correct and cure that mistake. But we have to have enforcement provisions in the legislation just so on campus they will take it serious and the administrators will be supported with something that, I guess, a culture or an effort to know that they've got to comply. And we've passed many bills where they have ignored our good intentions, but just because we just didn't have any provisions like that.
Understood. On page 7, starting on line 31, you describe a curriculum advisory committee. Is this a new, I don't think I've ever heard of a curriculum advisory committee. Is this a new advisory committee that's been created in the bill for higher education?
That's correct. It'd be 3 members appointed by the governor, 2 members by the lieutenant governor, 2 appointed by the speaker, the commissioner of higher education. There would be, the governor would appoint the chair, and that person would be from one of the existing gubernatorial appointees. And then that advisory committee would consider methods for determining the proper courses and condensing the number of core curriculum courses. We're trying to get to a point to where there's full transparency, not just to our families, but our students need to know, what kind of debt are they going to take on? And if there's 47 degrees in healthcare administration, but only 2 of those degrees would give them a fighting chance at earning a wage that would pay off the incredible debt they've taken on as a student like I did. It will just help us get there if we can take those 42 plus hours of those core curriculum requirements to get that degree and reduce it down into the 30s. Then the degree could be achieved faster, it would be less expensive, and we could have a recommendation by this committee to say, look, every course required in this core curriculum is tied to a degree of value where there's a return to that student, and that debt analysis comparison, they'd have a chance.
We all want students to be able to get an education that's going to be able to provide them a livelihood, right? Something to take care of their families, raise. But my concern is that many times, when young people are looking for a minor degree or something to offset their major, it's stuff that they want to enhance their time or their experience. For me personally, it wasn't so much about enhancement, but if I clept out of 15 hours of Spanish, the counselor at that point says, well, look, you can get a second degree in Latin American studies. Well, I had no clue what I was going to do or could do with a degree in Latin American studies, but it did end up helping me in the future. So sometimes I think that it feels like we're getting so prescriptive, and I guess the intention or the motive is right, but we're so prescriptive that we may be robbing students of an opportunity. You know, maybe they get their majors pre-law, or business, or biology, and their minor is art history because they love art. I just don't want us to do something to take classes and teaching out of the higher educational experience where students can start to find and develop who they are as a person.
Right.
And so that's the concern that I have, because we have a lot of technical schools. We have schools you can go to become a nurse, you can become, specifically what you want to be, and you can come in and out. And so I think this may just rob our universities of some of the diversity that's made them what they are. So appreciate you answering my questions. It's got a lot there, and a lot of ground has been covered already, so I'm going to listen for now. Thank you.
Thank you, Senator Menendez.
Senator West, what purpose?
A few questions of the author.
You yield.
I yield.
Send it up, and I'm not going to be, I should have said, I'm not going to duplicate everything else everyone else has said. A few questions as it relates to this commission that's being set up. How does this one differ from the coordinating board, the one that's being appointed by the governor, lieutenant governor, and speaker? How do they differ in terms of functions and responsibilities? I thought the Higher Education Coordinating Board was responsible for the very things that you're talking about, and that responsibility is articulated in the statute. Help me understand, what is the difference?
Well, it's another step. You're right, the coordinating board has some of these responsibilities, but at the same time, it is important for our regents as leaders and final decision makers for the university in hiring and firing the administrators they bring in, our chancellors that hire our presidents and establish the network.
Let me be more specific. This group that's going to be looking at the general curriculum and whether it aligns and whether or not the courses that are being taken have value, et cetera, isn't that what the coordinating board is supposed to be doing?
Well, yes, and this committee would be located at the coordinating board.
But why do we need another committee, given the fact that we have people that are appointed by the governor of the state of Texas serve on the coordinating board of higher education to do those particular functions? Isn't that just kind of being duplicitous?
Well, this is providing, additional work in this space to make sure, again, as I've mentioned, on getting our core curriculum set and making sure that we reach that debt analysis for students and degrees of value. But the coordinating board itself continues to function as it always has, but we're supplementing the coordinating board with a higher education footprint for recommendations on these core courses.
But again, sir, and this debate probably won't change it, but I want to make sure when we talk about it, that's what I thought. What's the responsibility of the coordinating board? Let me ask you that. What is the responsibility of the coordinating board?
There's overlap in both efforts, as you're implying, but at the same time, we feel like this legislation is necessary because these particular provisions are not being carried out by the coordinating board.
Well, I mean, but you would agree with me that they're supposed to be carried out by the coordinating board. What you're saying is they're not being carried out by the coordinating board. Would you agree with that, given that what you just said?
Not exactly. No,
not exactly.
Yeah,
not exactly.
I think we're establishing new policy here and requirements that will be placed upon these new committees to help us arrive at a new goal from 2025 forward that the coordinating board hasn't been focused on.
Okay, well, tell me this. What is it that the coordinating board is not doing that's now that you're establishing in new policy that, frankly, they could be doing if we charge them with that responsibility, as opposed to establishing more government?
Well, for instance, as I mentioned, the debt analysis review.
Had the coordinating board do that?
We're making sure that this happens at the coordinating board.
No, I'm saying as opposed to putting together more government. You like that more government piece?
Everything I find in this bill that is in this draft and the committee substitute is what I feel is not happening at the board.
No, that's a debate that we're having right now. We're saying that if it's not happening at the coordinating board, why don't we go ahead and give them those additional responsibilities to the coordinator to make sure it happens, as opposed to creating new government?
Well, this, in turn, as it's placed in statute, will be a directive to them to not go on a handshake deal or a call from us, our office, over to the board and hope that it works out. This is codifying our directives for the future of higher education, and this core curriculum review committee will be housed there.
And maybe we're misunderstanding each other. I'm saying I understand what you're talking about, but what you're doing is creating more government as opposed to giving those directives that you just mentioned to the responsible government that's already there, that being the coordinating board. Coordinating board is supposed to coordinate higher education. And if indeed what you desire, it would seem as though that they would be given that responsibility and directive as opposed to putting a new committee or new government in place.
Well, Senator West, we create advisory committees all the time on this floor for the refinance model of that we've all celebrated on community colleges, to the teacher vacancy task force, to what led to House Bill 3 on revamping all of school finance formulas, and you supported all of those. And so,
without question, and those were temporary. Those were temporary, not permanent.
Okay, so it was more government but temporary. Well, we'll look at this for success, and depending on the lifespan and the merit behind whether or not we continue it, we'll review that every 2 years when we come back here in the regular session.
Shouldn't we review what Senator Gutierrez just mentioned also every 2 years? Shouldn't we review that also? I thought it was a good idea.
We plan. That was my answer to Senator Gutierrez. We'll be ultimately reviewing the success of all of these policies. Yes.
Let me go on. You remember Senate Bill 25, where we were talking about the cost of education, higher education in the state of Texas, and
that's right. We're trying to get costs down in this bill.
Well, that's exactly my point.
Yes.
Okay. Senate Bill 25 that we passed, I think 2 sessions ago, maybe 2 or 3 sessions ago, was just. The purpose of it was just as you have articulated in this particular bill. And Higher Education Coordinating Board has been working on that. And based on what I'm being told, I hadn't seen the numbers, that the cost of higher education is going down, okay? But now we're putting in place another advisory committee, if you want to put it that way, to do what the coordinating board was directed to do 2 or 3 sessions ago as it relates to reducing the cost of higher education. And this body, if you recall, I think it was 31-0. Coming out of this body in terms of doing exactly, in many instances, what you're talking about now. Aligning the core curriculum, not only at our universities, but in higher education overall. And making certain that if you're taking a course in community college, that should apply to your terminal degree, assuming that that was your intention when you took the course. You remember that, don't you?
I do.
Okay. And so I'm trying to figure out, how is this differing in one aspect? So help me understand, how does this differ in one aspect?
It's different because when you talk about cost, you can talk about the institution, you can talk about the salary that goes to the professor or the chancellor or the president or any administrator. You can talk about all the paraprofessionals. You can talk about what our budget overall funds for higher education in total. But I'm talking about what it takes to get the cost to the student down.
Well, that was the purpose
and that is a very, very different conversation that doesn't ultimately ever convey from this floor and these policies in our budget.
Okay, so what was the purpose of Senate Bill 25 then, that you supported? That was the purpose of Senate Bill 25 when we passed it 2 or 3 sessions ago, sir.
And this is next chapter.
This is the next chapter, huh?
This is the next effort along those same lines to help our students understand what their debt analysis is going in, what their degree they're pursuing. Is it a degree of value that will lead them to an in-demand job that will pay them a good wage or a good salary?
I think that's a great
And then
purpose.
get the number of courses down so they can get there faster.
So then we take the persons that we put in place for Senate Bill 25, that is to do the same things you're talking about, and say, you continue your work, or do we just allow this new structure to take over what they've been doing?
I don't think that this effort supplants the policies in Senate Bill 25, but which Senate Bill 25 is not before us today.
Well, I'm just saying Senate Bill 25 is not before us today, but what I'm telling you is that Senate Bill 25 has addressed this very issue that you're coming up with, at least part of it, that you're coming up with in terms of higher education, given that we put in place that particular structure on a permanent basis in order to reduce the cost of students, the cost of college education for students and parents. That's what the purpose of it was. That's why over the last 3 sessions, the higher education and higher education being defined as community colleges and universities have come together to look at cost associated with providing a quality higher education at a lower cost. That was the whole purpose of it. And this particular bill, again, I've read it several times, seems to be putting in place another bureaucracy to do the same thing and duplicate what's already been put together in Senate Bill 25 by the Higher Education Coordinating Board.
Well, I'm not, the presiding officer has not recognized me on Senate Bill 25, so I don't have it in front of me or remember if it ties directly to general course curriculums and what the courses are within those curriculums, and then tying that to a debt analysis and tying that to degrees of value for the ultimate destination of the student to have all the information they need to make a good decision on the front end. If it does, and it's exactly the same, well, we can pass this bill. You know why? Because there won't be a single change in the higher education world going forward, so there won't be any disadvantage. So join me like you did in voting for Senate Bill 25, because if this bill's the same, then you're my partner, and we're voting together today on this bill.
We may not always agree on things, but I am your partner. We are partners.
We are.
And the great thing about partners, we can agree to disagree without being disagreeable. And again, I think what this is doing is creating additional structures. And I mean, you have the votes to pass it, so I'm not going to continue the debate. What I will say is this: in terms of putting together a review committee, you need to make certain, and I hope you will agree that that committee needs to be diverse in terms of racial diversity, gender, all persons who need to have a perspective considered as it relates to these degrees should be included on that committee. It shouldn't be all white guys, shouldn't be all black guys, shouldn't be all Hispanics. It needs to be our best and brightest from the various peoples that we have in the state of Texas that are on those committees. Would you agree?
I'll commit to you to strive towards choosing that committee based on the greatest amount of merit and diversity of viewpoint and perspective. And we can certainly grade papers on how it's established and who's serving, and if we feel like it accurately depicts the state of Texas on how these recommendations should be advised for the future of higher education.
Should professors, assuming this bill becomes law, should professors fear that they be violating any type of law if they teach about housing discrimination in the state, redlining and things of that nature?
Senator West, if there's any, just as it works on campus now, if there's any question by a professor on if they're in or out of compliance, they can check with university counsel and they'll
I'm talking about the chilling effect, or the potential chilling effect. You know what chilling effect is, right?
I do.
Okay, and so there's language in this bill that, as a policymaker, that I want to make sure we discuss in order to make certain the bill does not have a chilling effect. That's what I'm talking about right now. So, if you don't mind, and so I want to have a little debate about things that professors don't have to worry about, so to speak. In your bill, you talk about this is in first section of the bill under 51.315 that as part of the curriculum, a comprehensive review of the general education curriculum should not distort significant historical events or include a curriculum that teaches identity politics. So I would assume that if a professor was talking about redlining and housing discrimination, that wouldn't be distorting history, correct?
These would all be assumptions, and if they're important to the debate to provide the assumptions, it would be mainly it would be more important to rely on these committees once they're established to make recommendations based on a lot of different data that they pull in on what does and does not appropriately tie to core curriculum, leading to a degree of value. And so the rest of this is, there's obviously a line between teaching and promoting ideology. We've got it in the bill already that you absolutely should put it as the highest priority to never distort history, as Senator Gutierrez made a good point on. And that's important to me. So,
okay, and I know it is. That's why I want to have this few moments with you. If it's a fact, then it's not distorting history if it's a historical fact. Would you agree? Okay. You shook your head in the affirmative.
Correct.
Let the record reflect. So as it relates to, what do you mean when you say teaching identity politics? What do you mean by that?
Senator West, as I mentioned before, on these recommendations by these review committees, it will be important to tie these core curriculum, core courses to what they determine to be a degree of value that can help someone get out into the workforce and get a job.
I'm just asking you what you mean by your language in your bill now, that's all. I'm sorry, when you say teaching identity politics, I'm just trying to get, how do you define identity politics?
Yes, but what I'm saying is these review committees will establish and make recommendations to the regents based on their interpretations of exactly what is and would not be imposing ideology versus teaching it.
Would you agree with me?
Providing different perspectives versus imposing one.
I got you.
Yeah.
But would you agree with me that in order for them to do that, they would have to know what the intent of the author of the bill is before they can make those types of decisions? And that's why having debates like this, so they can go back on the record and say, what was the intent? How did they define it during the debate? So if we leave it like it is right now, they will have no idea in the world of exactly what your intent is as the author of this bill.
Senator West, I'll use a recent current event as an answer, right?
I'm sorry, say that again?
I'll use a recent current publication out of the battalion at A&M as an example of what we're trying to establish as it is a certain course tied to a degree of value. Now,
I didn't ask that, though.
This ties to identity politics.
Could you give me 1 second, please?
Yes, of course.
You ready? Okay, go ahead. I'm sorry.
So for identity politics, I have an article from A&M recently, right? And you asked specifically about identity politics, right? group membership being more important than the individuality, politics being a competition between demographic groups. And recently, the president at Texas A&M excluded a course, and also not only in excluding that course from their course recommendations for core curriculum credit, they went into discussions about other courses that might tie into identity politics and whether or not those courses should be offered as a core curriculum credit. That's the key to this bill, is it's not about all courses, it's about degrees of value and how to get there faster and cheaper. So these courses, Introduction to Lesbian, Gay, Bisexual, Transgender, and Queer Studies, a survey of the histories and theories regarding LGBTQ identities and communities, institutional ways in which homophobia, biphobia, and transphobia are systematically deployed. All of these were determined by A&M to not meet core curriculum credit requirements meant to provide an introductory knowledge base to ensure that students are well-rounded and equipped with skills necessary to be successful in the workforce.
All right, let me ask you this question.
Yes.
Now, as part of that section, hold on for 1 minute. These students that we are teaching are providing these core courses for, and I can't read where it is in your bill, but we need to prepare them to be able to function in society and to make certain that they are civically aware of their responsibilities as a citizen. Now, I understand you're talking about this is all core course. This doesn't say anything about elections or courses that you take for your elections and things of that nature. Just the core curriculum, correct?
That's correct.
Okay. And so the core curriculum also has a history component, in most instances, an English component, a math component, all those different components, correct?
That's correct.
Okay. And so as it relates to history, as long as the history is based on facts, then you would consider that relevant. And as the committees are reviewing these core curriculum for the various universities, that they can take into consideration facts that have occurred in history, i.e. slavery, i.e. Different court decisions, Dred Scott decisions, things of that nature, to determine whether or not a history course should in fact be included in the core curriculum. Am I correct about that?
Mostly.
Where am I wrong?
As long as that course, whether it be history or math, didn't include examples of the same identity politics that I just read off from the publication from A&M and the decisions for why they removed certain courses, it would be certainly within the spirit and intent of the bill. But again, these review committees are being established to provide exactly the type of advisory information that is needed to make these decisions. So we're launching the opportunity for an advisory committee to get us back to degrees of value, to get us back to affordable degrees, and to get us back to a faster track where our college students pursuing that higher education path can enter college and maybe arrive at that degree of value within 30 plus course hours instead of 40 plus course hours.
I agree with you 100% on that side of it.
Thank you.
But when we sit up and say that that the curriculum is supposed to be foundational and fundamental to a sound post-secondary education, are necessary to prepare students for civic and professional life, right? That's on, I'm looking at the long form right there, on line 49. And we say civic and professional life. You say civic and professional life in this world, in this country, in the state of Texas. And let me tell you what I'm asking. The reality is that this country, this world is more diverse now than it's ever been. And we've got to make certain that as our kids graduate from college, they know how to function in a complex society with different persons, regardless of their color of their skin, their gender, or their other differences. Would you not agree?
That's the purpose of the bill. So I absolutely agree on that. In fact, what you mentioned tied to students being prepared just in the category of soft skills alone.
Right, soft skills.
Our CEOs across this state are saying,
you better believe it.
We've got to get it together. But Senator West, when we do a search at the University of Texas on keyword terms for course schedules that are offered, and the top 3 terms mentioned most frequently are gender, more than 400 times, race, 200 times, identity, 175 times, the Declaration of Independence, 10 times, Abraham Lincoln, less than 10 times.
What point are you making?
Federalist Papers, less than 10 times. So
I understand what you're saying.
When I say civic, I mean civic.
Well, the question is, when you say civic, are you only talking about the Declaration of Independence, which I agree. We've got to make certain. I mean, there have been times when I used to look at one of those night shows, I can't recall what it is, and they'd be out on the street and they'd ask people, what is the Declaration of Independence? And they wouldn't know what it is, okay? I understand what you're saying. Right. But I also understand that in order for our children to be able to function, depending upon whether they're going to get out of the cocoon, they've got to be prepared to interact with people from all over the world. I look at that as civic also.
That's correct. That diversity of viewpoint could not be more important to me as the intent behind exactly what we're providing here. But true diversity based on viewpoint is...
That's not, sir, all due respect, and I will defend your right to have your opinion. That's not the entire world, just diversity of viewpoint. That's not the entire world.
It's very important to me in this world. I know
it's important to me, but it's not the only diversity that we need to make certain our kids are prepared to be able to function in.
Well, you find that viewpoint in all types of people, right? So you're assuming that I'm saying diversity of viewpoints important to me only from certain people. That's not the case. I'm talking about all people in their perspectives.
That's why you've got to take into consideration ethnicity, because you're going to get that diversity of viewpoint when you have people from different backgrounds sitting down and talking about different
We've had
issues.
a lot of discussions about this.
That's exactly right. Yeah. And I know that the hour is getting late, but I wanted to make certain that we had this debate, and I'm going to ask that it be spread upon the Journal of the Senate for future consideration.
Thank you, Senator West.
Are you guys finally finished here? I think motion to suspend is not a debatable motion, but you guys were having a good discussion. I didn't want to interrupt it here. Secretary will call the roll.
Alvarado, Bencourt, Birdwell, Blanco, Campbell, Cook.
20 ayes, 11 nays. The rule suspended. Chair lays on second reading. Committee substitute for Senate Bill 37. Secretary will read the caption.
Committee substitute Senate Bill 37 relating to the governance of public institutions of higher education.
Members, there is an amendment. Secretary will read the amendment.
Floor amendment number 1 by Creighton.
You're recognized on your amendment.
Thank you, Mr. President. Members, this amendment provides clarifying language that restores certain provisions from the original bill filed relating to governing board authority, allowing the governing boards to create subcommittees to assist in the workload. It refines language surrounding curriculum review, faculty senate reforms in the office of the ombudsman, and it also codifies the definition of shared governance. I move adoption.
Senator Eckhart, what purpose?
To ask questions of the author on his amendment.
You're recognized.
Of course, yes, I yield.
So how many pages long is this amendment?
Let's see. It's a long bill, so the amendment itself is 13 pages, yes.
When did this amendment when was it apparent that this amendment was going to be brought on the floor?
When was it apparent? We've been working on the amendment since we left the committee process. We've also been working with most of the offices on the same, Senator Eckhart.
When was the first time this amendment was circulated generally to the full body?
I don't have time frames.
You don't have time frames. I can tell you this is the first time I've seen it. So I guess right now is the first time it's been circulated to the entire chamber.
The amendment was just distributed from the dais, correct?
Would you consider moving for a slight recess so that we could at least read the 13-page amendment so that we could have an informed vote on it?
Senator Eckhart, we've been working with various offices on changes and review of the amendment and different provisions within the amendment for several weeks now.
Do you have an expectation that your fellow members of the chamber should make an informed vote on a 13-page amendment?
Senator Eckhart, we have multiple page amendments all the time during session. Yes, I do.
I'm so glad that you agree that we should all have the opportunity to make an informed vote. And I would suggest that we have a slight pause to give us the opportunity to actually read the 13 pages.
I'm very comfortable with a slight pause. If you would like to take advantage of reading the amendment, do you really want to read the amendment? Is that your goal, or are you making a spectacle out of the fact that you didn't get it in time? Let me know your preference, because we have everybody waiting. But I will honor that request out of etiquette if that's truly your request, and there's a chance you may vote for the bill based on what's in the amendment. Is there that chance?
Senator, there is every expectation that every member of this chamber desires to make informed votes. I resent your suggestion that the mere desire to read what I'm about to vote on is somehow wasting the chamber's time.
Well, there's parity in our resentment, because with that parity, I resent that I'm not being transparent any more than any other bill that has an amendment on the floor.
Members, you can either grant the pause or not grant the pause.
Happy to grant a pause. We'll pause. Mr. President, what's appropriate for?
How long does it take to read 13 pages?
13 pages, I would say 10 minutes to read 13 pages.
Why don't you temporarily postpone the bill for 10 minutes?
I'm happy to do so.
We'll postpone consideration of the amendment for 10 minutes.
Thank you very much. I appreciate it.
Thank you, Mr. President.
Any objection to doing that? You all have 10 minutes. We'll start promptly at 4. Members, it's 4 p.m. We will resume. Members, does anyone have questions on floor amendment number 1? Senator Cook, what purpose?
I just want to ask a couple questions about the amendment.
Do you recognize?
I will
I'm sorry. Do you yield? I'm sorry.
Of course, I yield.
Thank you, Senator Crane. Thank you, Mr. President. And I will just say 10 minutes was not enough time, and I do read every single thing that I vote on. So I really, really appreciate having that moment to process through some of this.
Yeah.
So on page 3, number 1, it says that they can close the degree program if the program is not basically approved by this new body. Is that correct? They'll just shut down an entire program from a university?
That's correct.
So they just have the power to censor what kind of programs and degrees these universities are able to hold.
And how it ties to a core curriculum component for credit course tied to a degree of value. Correct.
Do you agree this feels like censorship?
No.
Okay.
No, I think universities make decisions on courses to include and exclude all the time.
Right. And so what needs to change?
What has changed is a directive to, just like I explained for the last few hours, a directive to establish a lower number of required course credit hours to get to a degree of value, and also to make a comparison on the debt analysis so our students know what are they borrowing, what kind of degree of value are they going to arrive at hopefully 4 years later, and what does the workforce offer them for that degree.
So I was listening, but this amendment contains new language about closing the degree program. Is that not new to the bill?
It certainly could. They could choose not to close a degree program as well. Those recommendations will be from the committee established by the core provisions of the bill. I'm happy to go through the explanation of the amendment, but I haven't been afforded the opportunity to because of the questions. So I can, what I'm saying is I can explain further on the rest of the amendment, but we worked with the major institutions all over the state coming out of committee, all of our university systems, because they had concerns about the original bill. And so in working with U of H, Texas Women's, UT, A&M, the Higher Education Coordinating Board, with their concerns about the original bill, we arrived at the substitute language based on those negotiations and working with them to do what they consider to provide a better piece of policy, a piece of legislation.
Okay. And on page 5.
Yes.
Approving or denying the hiring of an individual for the position. And also there's something about monitoring every single, basically, job posting. Is that correct? Am I reading that correctly on?
Correct, yes.
On page 6?
Yes, there would be there would certainly be a review of the job postings available. Of course, with one university system, there could be over 30,000 professors that are employed and all the other employment related to that system. But the important clarifying point is that at the end of the day, the regents are, the buck stops there, and they can reverse a hiring decision that they feel was not a good decision.
Mm-hmm.
That's
okay.
correct.
And then I think the last part I had a question about on here. On this line on page 10 of the amendment, strikes, text, and substitutes, including recommending to the legislature the institution not be allowed to spend money appropriated to the institution for a state fiscal year until the institution's governing board certifies compliance. So is that, and again, I had 10 minutes to read the amendment. Does that say that the entire university can't spend any money for a year?
Yeah, that would be in the non-compliant phase or provisions of the bill, Senator Cook. So if there wasn't within the cure period, the university, there's a cure period in the bill where they're allowed to correct any non-compliant actions. But if they chose just not to make any of those corrections, then this language ties together with what we passed in Senate Bill 17 last session, where there would be financial implications to not being compliant with state law.
Okay, I've got constituents reaching out to me saying that like this is the death of higher ed, this is unprecedented censorship. They're extremely concerned about free speech, about teaching Texans to be critical thinkers. I really appreciate you answering my questions, and I would ask that all of us get to read longer amendments ahead of time. It just helps us be way more thoughtful as we collaborate in the chamber. So thank you for answering my questions.
Thank you, Senator Cook.
The question is on the adoption of the amendment. Secretary will call the roll.
Alvarado, Bettencourt, Bardwell.
20 ayes, 11 nays. The amendment is adopted. Members, the following amendment. Secretary will read the amendment.
Floor Amendment number 2 by Creighton.
Senator Creighton, on your amendment.
Thank you, Mr. President. Members, this amendment clarifies that the director of the Ombudsman's office would be appointed by the governor and confirmed by the Senate. The Higher Education Coordinating Board members are also appointed by the governor, so there would be alignment with both. With that, I move adoption. Thank you,
Senator
Mr.
Menendez,
President.
what purpose?
Quick question of the author of the
Do you
amendment.
yield?
Of course.
Thank you, Mr. President. Thank you, Senator. So the ombudsman, this ombudsman would be to be an ombudsman for students, for faculty. What's the role of this ombudsman?
The ombudsman position, Senator Menendez, in the original bill would, and with the amendment, would provide, being housed at the Higher Education Coordinating Board, would provide the role of serving as a compliance officer to make sure that, especially when we're not in session for that year and a half, that the universities are in compliance with state law. They could work with general counsel for each of the university systems. Many times there's confusion by our general counsels on what is and is not the spirit and intent of the legislation that we pass, but we're not in session and our committee's not convened to provide that feedback.
The ombudsman is in the way you envision it working in your bill is to help the general counsels of the universities find out whether they're going to be in compliance with state laws. That's what you're saying?
That's correct. This position would hold universities accountable and be a monitoring position for making sure that our wishes and what our goals are within the policy that we pass are carried out, especially when our committee and this session is, in our session, is not convened.
Thank you for answering my questions.
Thank you, Senator Menendez.
Any objection on the amendment? Hearing none. Amendment is adopted. Members, there is a following amendment. Secretary, read the amendment.
Floor Amendment number 3 by Gutierrez.
Senator Gutierrez, on your amendment.
Thank you, Mr. President. Members, this is a darn good amendment, if I must say so myself. The bill establishes a stick. You get these 4 categories where you're either rewarded, gold star, you're monitored, you're sanctioned, or you're sunsetted. The bill, and by the author's own admission, if you get down to the sanction or sunset part, you lose funding. It says that in the bill. And so what this amendment does, it offers an incentive for compliance. So compliant universities that do comply will be able to get the carrot by virtue of this amendment. And what it does, it takes the top 10%. I know Senator Creighton was concerned about student debt, as am I. In Texas, the average student loan debt for borrowers is around $33,000, and we have students totally combined debt of $128.7 billion. All this amendment does, it says if a university or system complies to this bill, then there would be an award, and the award would go to students entering into those universities. At the top 10% level, you would have a 100% fully funded education if you're in the top percent. And the state of Texas can pay for this because it only costs $500 million a year, $1 billion per biennium. We should reward compliance. The bill is a stick. Let's have a carrot. And with that, I move adoption.
Senator Creighton.
Thank you, Mr. President. Members, I certainly respect the intent of the amendment and Senator Gutierrez's goals. We are coming into, hopefully, when this regular session expires at the beginning of June, which we're all praying for, we're coming into an interim with a request on something very similar to this, but I would like the time to be able to gauge that through the committee process or even enhance it. And so for that reason, I would oppose the amendment.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell.
11 yes votes, 20 no votes. The amendment fails. Senator Creighton, you're recognized. Passage to engrossment.
Thank you, Mr. President. Move passage to engrossment for committee substitute for Senate Bill 37.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell.
20 ayes, 11 nays. Bill passed to engrossment. You'll hold right there.
Thank you, Mr. President and members.
Mr. Doorkeeper.
Mr. President, there's a message from the House.
Submit the messenger.
Mr. President, I am directed by the House to inform the Senate.
Thank you. Senator Campbell, you're recognized to suspend the regular order of business committee substitute for Senate Bill 762. Members, this is the third reading bill.
Thank you. Yes, sir. Thank you, Mr. President. Members, I move that we suspend the regular order of business and take up committee substitute Senate Bill 762.
Senator Cook, what purpose?
To speak on the bill.
Okay, that would be on third reading.
Oh, my mistake. Thank you.
No worries. Secretary will call the roll.
Alvarado, Betancourt, Birdwell.
23 ayes and 8 nays. The rule is suspended. Chair lays out in third reading and final passage committee substitute for Senate Bill 762. Secretary, read the caption.
Committee substitute Senate Bill 762 relating to the display of flags in public schools.
Senator Cook, you're now recognized to speak on the bill.
Thank you, Mr. President. Members, flags are only pieces of fabric, but we have invested profound meaning into these symbols. Some flags represent acceptance and inclusion and the fundamental messages that everyone deserves to feel safe and welcome. Other flags with documented histories of promoting racism, hatred, and division have no place in our schools. This bill would eliminate some of those symbols, like symbols of hate, Confederate flags from our classrooms, but it will also remove symbols of love, acceptance, and belonging, and we shouldn't be equating these messages. It's truly devastating to me that this bill fails to distinguish between messages of hate and those of community. If pride flags are political, then so are the values of respect and belonging. Our students deserve better than a false neutrality. This bill also targets one group in particular, LGBTQ+ students and teachers. And for this reason, I am voting no. Thank you so much, Mr. President.
Thank you, Senator Cook. You're recognized on final passage.
So moved.
Senator Campbell.
So moved. Final passage for committee substitute Senate Bill 6.
I didn't see your light.
Oh.
Senator Blanco, what purpose?
Speak on the bill.
You're recognized.
Thank you, Mr. President. Members, I rise to support Senate Bill 762 because as a lawmaker, I believe that our public schools should be places of education and remain impartial in their public displays, providing a space for students to learn and grow without feeling their identities or beliefs overshadowed by external symbols. Impartiality doesn't mean avoiding tough conversations about race. It doesn't mean avoiding tough conversations about history. And it definitely doesn't mean avoiding conversations about equality and inclusivity. Those are critical to development of our students and our citizens. But the open door that allows displays of inclusivity is also left open to displays of discrimination and hate, like the Confederate flag, or a flag with a swastika, or others. So my vote for Senate Bill 762 is not about limiting expression, but upholding my commitment to ensuring that every student feels safe, respected, and valued in our schools. So we can be both inclusive and intentional in creating a learning environment that upholds dignity of every student without external symbols. For that reason, I'll be voting aye on the bill. Thank you.
Thank you, Senator Blanco. The Secretary will call the roll.
Alvarado, Betancourt, Caldwell, Blanco.
23 ayes and 8 nays. Bill is finally passed. Thank you, Senator.
Thank you. Thank you, members.
Chair announces signing of the following in the presence of the Senate.
SCR 47.
Any objection? Following motion in writing, Secretary, read the motion.
Motion in writing. Mr. President, I ask unanimous consent for Senate Bill 2695 relating to education programs to enable certain students in advanced practice registered nurses to practice medicine in certain rural counties to be withdrawn from the Committee on Education K through 16 and re-referred to the Committee on Health and Human Services. Motion by Senator Kolkhorst. Senator Creighton, Chair Committee from which bill is being withdrawn. Senator Kolkhorst, Chair Committee to which bill is being re-referred.
Any objection? Hearing none. Motion is adopted. Members, the President's desk is clear. And Senator West, I'm going to come to you in a moment. Let me check for other announcements. Any announcements, members? Senator Birdwell?
Thank you, Mr. President. Members, I'd like to remind the members that the Committee on Border Security will convene to consider Senate Bill 2601 by Senator Blanco in the Betty King Room 2E20 immediately upon adjournment today. Thank you, Mr. President and members.
Senator King?
Thank you, Mr. President. I move to suspend the 24-hour posting rule in accordance with Senate Rules 1110 and 1118 so that the City Committee on Economic Development can meet today, Tuesday, April 15th, 2025, in 2E9, the Senate press room, immediately upon adjournment to consider pending business. If there are no objections, I move suspension.
Any objection? Hearing none. Senator Kolkhorst?
Thank you, Mr. President. This is just an announcement. We are posted, Senate Health and Human Services, to meet on this floor, right here in the Senate chamber, upon adjournment or recess, whichever is so decided by the President. And just for point of reference, we'll make that time certain, 4:40.
Senator Hinojosa from Nueces.
Thank you, Mr. President. Members, just a quick announcement that the local and uncontested calendar has been placed on your desk to review before the calendar to be held in the Senate chamber on Wednesday, April 16th at 1 p.m.
Thank you. Senator Creighton.
Thank you, Mr. President. Members, the Senate Committee on Education K through 16 will reconvene at 5 p.m. today, April 15th in E1028 to continue our agenda.
Members, can I have your attention? Would you take a seat, please? Senator Hughes or Senator Senator Hughes, can you take your seat? Other senators, thank you. Senator Sparks, everybody, we want everybody seated. Thank you. Senator West, you're recognized.
Thank you very much, Mr. President and members. I'm saddened to announce again, Senator Cole, of course, announced yesterday, or day before yesterday, there's been another shooting. Public school here in our state, at the Wilmer Hutchins High School, the high school I graduated from. There were 3 to 4 students that were actually shot, and they range from serious condition to just being grazed by a bullet. And so this is happening more frequently in our state. I ask that you keep the students in your prayers, especially the one that is real serious at this point, and that you keep them in your prayers as you go to prayer this evening. I just want to make sure I reported that to you, and I'll keep you up on exactly what the condition is. Thank you, Mr. President.
Thank you, Senator West. In our prayers indeed. The chair recognizes the Dean of the Senate for a motion.
Thank you, Mr. President. I move that the Senate recess until 11 a.m. Wednesday, April 16th.
Any objection? Hearing none, the Senate stands in recess until 11 a.m. Wednesday, April 16th. Thank you, members.